It's sweet. In the streets with it. These YouTube streets. Let's build it. Content after content. We on the block. Lego. And as a daily reminder, hit that like and subscribe so you can get the vibes, you know it, and notified every time. Let ride. It's sweet. It's Sweet TV.
Big old salute. We are back, y'all. We are back with another live video. And I found some more content, y'all. Y'all not gonna believe this. You probably remember it. You probably remember hearing about this, man. You remember them students out there in Idaho that was in their home and was unalive, and nobody knew what the heck done happened and what the heck done went down. Well, that trial is set to begin. It's gonna start August of 2025, and it's expected to last to November 2025. This is one of the craziest cases you probably gonna see. Because let's be honest, y'all, it's looking like they don't have evidence, and today they're having a hearing, and we're gonna take a closer look, man. I already got it queued up, so if you just coming in, okay, yeah. All right, so if you're just coming in, go ahead and do me a favor and double tap that screen, hit the like button. I'm gonna get y'all caught up a little bit in a second with more information on this. But we have a hearing we about to take a look at, and I'm gonna react to for y'all real quick.
We have the Idaho College murder case. We're now hearing from a former roommate who once lived at the house where the killings took place. Kaylee Whitworth is here in the studio with us and has more. Good morning to you, Kaylee.
Robin, good morning. So Ashlyn Couch moved out of that house on King Road months before her friends were murdered. And this morning, she shares the memories, both happy and haunting, including the moment she got that vandal alert that changed everything.
I mean, I couldn't even walk to my car in the dark for months after, it happened.
Fear lingering with Ashlyn Couch after her friends were stabbed to death in their off-campus home in Moscow, Idaho, a home where she too once lived.
It crosses my mind more that that could have happened while I was there.
Real quick, do anybody remember this story? Do anybody remember when this story first came out? Everybody was posted. It was a winner. Do anybody remember? Just in case you don't, let me refresh you.
And, you never know, how long someone is watching your house.
The 6th bedroom on King Road was hers. And now this morning, she's speaking out for the first time on camera since Kaylee Goncalves, Maddison Mogen, Xanax Kernodle, and her boyfriend Ethan Chapin were murdered in November of 2022. Ashlyn initially signed the lease to live in the popular off-campus home, telling our station KXLY that she moved out in May of 2022 after graduating the semester before. But she stayed close with the girls, especially Maddie, sharing the last message she sent to her after getting an alert from the University of Idaho that there had been a suspected homicide.
I texted our group of friends and I just had said, has anyone heard from Maddie? And I remember my last text message to her was are you okay? And I feel right then and there, I kind of just knew that something was wrong.
The man charged with their murders, Bryan Kohberger, a judge entering a not guilty plea on his behalf, as his defense team says he was out driving that cold November night, as he often did, to hike or stargaze. But prosecutors allegedly linking Kohberger to the heinous crimes through DNA left on the button strap of a knife sheath found underneath Maddie.
You wish that you could just say goodbye.
Ooh, it's heating up. What y'all think about this? What y'all think about this? He facing death. We about to get into the hearing though. Hit that like button if you come in there. If you're new to the channel, hit that subscribe button.
And that's one thing that I just wish that I could do at least one more time, is like, you know, just give her one last hug, just to be able to say goodbye.
Now, the home that they shared has been torn down. The next hearing in this case is May 14th, and Kohberger's attorney, Ann Taylor, says she will deliver a witness list and exhibits that she says will support his alleged alibi. And you guys might remember they've also said they'll rely heavily on expert testimony from cell phone experts to.
Now, we have been here before, y'all. Salute to everybody coming in. I got another one. We have been here before, y'all. We got another one. Live reaction. Salute to everybody who just coming in, man. So it's a hearing going on right now today about Kohberger. But before we get into the hearing, for the people who don't know what's going on, don't worry, I got you. Now, here's what we know. Here is the victims that were staying in this home that fatal day, y'all. Students that was going to college, as well as the defendant was going to college. Now, here's what we know. 4 University of Idaho students were unalive and found stabbed to death November 13th, 2022, around 4 a.m. Victims Ethan Chapin, 20 years old, Xana, 20 years old, Maddison, 21 years old, and Kaylee, 21 years old, were all found in that house, y'all. Now, no one knows what really happened, but the defense is saying that he is innocent, and the DA office is saying they have evidence. So today we're going to get into the hearing. The trial starts again August 2025 and is expected to last until November of 2025. Now, what you're going to see, let me show you this. The police did not do a search on his apartment, that's Bryan Kohberger, until 7 weeks after the unaliving. When that happened, 50 items in his apartment were tested for DNA, and only 2 items were tested positive for a brown reddish stain, which is known as blood, y'all, also known as blood. Were found on the pillow casing and a mattress pad that had a little drip of blood stain. Now let's get into it. Salute everybody coming into the building. This is going to be a crazy trial. Hopefully these young kids, college students, get the justice that they solely deserve, y'all. Now let's get into it.
In that window between 2009 and 2023. And I think the court should consider that and have that information. We also need to make a record in the event that there was ever a conviction in this case.
Thank you. Any rebuttal?
Very briefly, Your Honor. I would just note that the defense did submit an affidavit. The court can review that. It clearly indicates what she would testify to if the court were to allow her to testify. So we don't really need to make a record because it already exists in the form of that affidavit. Thank you.
All right, thank you. All right. The court having reviewed the materials, believes that given the concerns about the current justiciability of the, or ripeness, if you will, of the issue, I do believe that the declaration is a sufficient proffer of what that general testimony would be that would allow us to discuss the issue. And so for the time being, I'm not going to hear from Ms. Wolf, or Dr. Wolf, I should say, her testimony. The declaration is an appropriate proffer. I will hear the merits of the motion based upon that proffer next. All right. So let's hear that from the defense.
Thank you, Your Honor. I would ask the court for leave to supplement that declaration, the information that is more recent between 2010 studies and a book that was published that is relied upon by Dr. Wolf. That's not contained in the declaration. And I would like to make that part of the record too from her. So if the court continues to have her testimony not be allowed, I would ask that I be allowed after the fact to make that part of the record.
You can submit that, and I will then hear any objections to that, and I will consider that.
Okay. Thank you, Your Honor. Then moving on to our argument, and I will largely not repeat what's in our brief since the court has had a chance to take a look at that. We think that the court ought to strike the death penalty in this case and not allow the case to go forward as a death penalty case because Idaho does not have a current means of executing anybody.
All right, boom. Let's start right there. The defense is first saying, first thing first, my client is guilty. But how about we strike the death penalty off the table? Because Idaho don't even have a way of carrying out death because they don't even do this type of thing. Never happens, y'all. This type of grisly murder never happens, y'all. Imagine being in your house at the middle of the night and somebody coming into your house attacking you. And what's so crazy is he was in college too, y'all, going to school for criminals law, some type of criminal law. He had a PhD. Let me get my notes. PhD in criminology. And he also was a teaching assistant at Washington State University. This is the man that's being alleged to have done these heinous crimes. Something is off about this, but we're going to get to the bottom line. But what's happening right now, they're trying to get death off the table. Because what she's saying, they don't even have a way of carrying it out in Idaho. So let's go.
When somebody sits on death row and there's no real means of executing them, that is dehumanizing to that person. That's similar.
Say there's no means under Idaho law, the method of execution is lethal injection, and if unavailable, then the firing squad. You rely significantly on the
boom. Now this is what got me, y'all. Did anybody know that if Idaho couldn't get you by lethal injection, it's about to get deep. I'm not gonna talk too much. I'm just gonna want to let y'all know what's going on as you slide through. Definitely hit that like button. If you're new to the channel, go ahead and subscribe. Now, in Idaho, because state to state is different, they have a firing squad. Judge, please elaborate on that.
The idea that lethal injection is not available based upon the quote unquote botched execution of Mr. Creech. It seems to me that was a particularized incident wherein Mr. Creech, the execution really hadn't even begun yet in the sense that they couldn't locate a vein. I don't see how that issue is universal.
Your Honor, I would agree that Mr. Creech's, the situation that happened to him was unique to him. I don't think he's the only person that has ever had that happen. Not in the state of Idaho, but I think that that's happened before when the means of execution couldn't be employed at the time. But since we're talking about Idaho, I think we should look at what happened in the Procedural case too. And in that case, there was no ability to obtain the chemicals to kill him with. And so his execution, his death warrant expired without him being executed. After that happened, Idaho passed legislation that would allow the Department of Corrections to obtain the chemicals to kill somebody in secrecy. After that happened, there's still a lot of difficulty getting the chemicals because pharmaceutical companies don't like to have
They
their.
have obtained them twice now, since then.
They've obtained them twice for Creech, yes. Now, something has changed in the death chamber for how they will try to execute Creech. I don't know what that is. That's probably one of those things that we'll learn a little bit more about through Creech's.
Well, I think that they're going to utilize a central venous catheter.
Real quick, let me read this comment. Warren K said, from PhD to death penalty. Let's talk about it, y'all. So basically, she's saying, why would y'all have my client, just in case you don't understand what's going on? He hasn't been convicted guilty of this crime. So why should he sit on death row while he wait for a fair trial? That's what the argument is on the table. And the judge is saying what he's saying, and we're about to get right back to it.
In other words, accessing a central vein rather than a peripheral vein. My understanding that there's federal law approving that procedure, as well as a recent decision by the district court approving that procedure. I think that's the difference.
And I think, looking forward, we just don't have those answers yet. We don't know how that's going to unfold. I don't believe his execution is moving forward as is scheduled. And if we look at the immediate history in Idaho, and that's what I'm looking at when I'm standing before you representing Mr. Kohberger and saying to you that Idaho doesn't have a real means of executing someone. The firing squad ended up on the books because of the difficulty obtaining the drugs to kill somebody. That's why the firing squad came back. The history of the firing squad, which is really well written by Mr. Logston in our briefing, is that it sat on Idaho's books for years. And in 2009, it came off in light of the Bays decision. When you think about it coming off in light of the Bays decision, and you look at what's happened since the Bays decision, and we're going to talk about that a little bit later today when we're talking about evolving standards of decency, we'll talk about how things have changed in this country since then. But for these purposes, when you look at that and you realize Idaho brings it back in 2023, they bring it back because it's not reliable to believe they're always going to be able to get the chemicals to execute somebody. And that's the real problem here. The firing squad hasn't been funded well enough to be built.
I think they're building it right now, as I recall from the media, at least, that the construction's actually underway. But I may be wrong about that.
Well, I haven't talked to the director of the Department of Corrections, and that's probably who I would take my word from if that's actually happening right now. I think there's some additional problems with the firing squad, though. I think there's some problems with the way our statute lays it out, too. If you read our statute, and the court just summarized it, it's lethal injection unless it's not available, and then it's going to be the firing squad. But the way that's written is that it's firing squad unless the director of the Department of Corrections says, I have the chemicals and we can do lethal injection. And I think there's 5 days that exist for the director of the Department of Corrections to say, no, we have the drugs, we can do lethal injection now. That is problematic. There's not a choice or an election, and other states have an election for the condemned person to choose from, but Idaho's not allowing that. Additionally, the information that I think is really important to the court is to understand things and advances that have happened in understanding conscious pain and suffering. If Dr. Wolf had been allowed to testify, she would tell you that she relies on studies from 2010, a working group from 2010, and a book that was published later than that even, and that's post the Bays decision. And that talks about understanding what a person is conscious and aware of when they face the firing squad. That's information that's important for the court when considering whether or not to strike the death penalty, because Idaho's means of execution really doesn't exist. Thank you, Your Honor.
Can I ask you, even if your motion were,
We can already see this gonna be a whole. This is already leaving a different taste in my mouth. This is a whole different potato. Since we in Idaho, this is a loaded one, huh? Let's go. Y'all hit that like button. If you're new to the channel, go ahead and subscribe if you're enjoying the vibes. Let's see what the judge is about to say.
right. And even accepting as true that the current means of execution are either unavailable or would violate the Eighth Amendment as cruel and unusual.
And that's what I was saying. So when he say firing squad, do he mean like literally, like, you know, a firing squad? It hasn't been done. So let's learn about some of the amendments, shall we? Let's go.
How do you get around Buckwell? You've not provided a alternate means of execution.
Well,
And I know, and I understand from your perspective, it's not something defense counsel wants to do, is to say, no, do it this way. Execute my client this way. But Buckwell provides that if you're going to challenge the means of execution, you have to, as a condition proceeding, provide a available or an alternate, I should say, means of execution.
I would say, to Your Honor, that we're not at the place where we would have to make that decision yet.
That speak to the justiciability of the issue overall.
I don't think it does. And I think that the separation and the difference is that we are in a place where we're preparing this case to go to trial. We represent Mr. Kohberger, who sits there, an innocent man right now.
Yo, did anybody get the bright idea that I got? She might have a good point. Is this judge biased? Do he already know what he gonna like rain down as far as his judgment? Like, he's saying, listen, death is on the table. She's saying, sir, but my client is still innocent. What do this judge know that none of us might not know, y'all? Let's go.
But we're preparing this case as a capital case with all of the things that that involves, all of the requirements that are upon counsel take a lot of time, a lot of work, and a lot of money to do this. And so I think when we're looking at the constitutionality of the execution, I think that's different than if there was a conviction and if there was a death sentence and if the post-conviction proceeding and the appeals were unsuccessful for Mr. Kohberger.
Doesn't that speak to your motion in the sense that you're saying take the death penalty off the table, don't let the state put on that evidence because the current methods, in your view, are either unavailable or unconstitutional. But the reality is if he is convicted, we know it's going to be a decade plus before that sentence would be carried out. And who knows what the methods may be then. And, you know, I think that's part of why you're saying you shouldn't have to comply with Buckwell. But it seems to me that that same rationale then applies to why I should even consider this motion. Why wouldn't we wait until that time frame to see what the current methods are? Who knows what technologically is going to be available at that time.
I definitely hear what the court's saying. I would come back to saying that we're not in the place where he's challenging the methods that's about to be employed. We are decades away from that, if that were to even happen. But what I'm saying is, I don't believe that our Constitution allows for us to move forward and make him sit on death row for years and years and years when the way Idaho's doing it right now isn't really working. It's not a realistic option. I think to have him sit on death row and say, Idaho's going to figure out how to kill you at some point in the future in a way that isn't cruel and unusual and in violation of.
Man, let's start right there, man. Idaho is not playing, man. But you know what? Y'all not playing either. Well, I think y'all are playing. Y'all know what's going on. Y'all know where I'm about to go with this, man. Can we get the lights up, man? Like, for real. Let's get the lights up, y'all. We can get the lights up some more, or I can keep breaking it down. What y'all want to do? If you're new to the channel and you feeling the vibe, go ahead and subscribe.
It's we in the streets with it. These YouTube streets. Let's build it. Content after content. We on the block. Lego. And as a daily reminder, hit that like and subscribe so you can get the vibes, you know it, and notified every time. Let ride. It's sweet. It's sweet
Right.
TV.
I just don't think that the constitutional protections allow that to happen. I think that
So you're saying the anxiety of not knowing is the constitutional violation?
I say that, and I believe that the Troop versus Doles was cited in the brief, and the comparison there is what I'm saying the Constitution doesn't allow. It is anxiety, it is fear, it is the not knowing.
I mean, to be fair, the Idaho Supreme Court just ruled that anxiety and fear in the Creech case was not sufficient to preclude his execution just this week.
I read
Ooh. Man, when it start off like this, y'all, let's be honest. Can we be honest? I appreciate y'all for getting them lights up, and I see we got over 30 subscribers. Appreciate everybody that hit that subscribe button. Let's be honest about that. Now, this is y'all know what I'm about to say. This is nasty work. This is nasty work. She's trying to, what does the judge know that the defense don't know yet? She should know everything. Everything should be on the table. And she's defending this man, and they saying they got evidence. 4 people unalive in the middle of the night. College students going to school. These ain't no regular civilians. These are college kids. Let me say the ages again for people who just coming in. Ethan was 20. Zayna was 20. Maddison was 21. And Kaylee was only 21, where he broke into their house. Now, we got to ask ourselves a question. Could a man with a PhD in criminology really be breaking into people's houses and unaliving them in the middle of the night? Something just doesn't sit right about this whole case, man. Let them cook. Fever Faye, you know what time it is, man. But I ain't gonna cook too long. Y'all get the lights up and let's get back to it, because the judge is up to something. He's saying just yesterday they was doing this. So how you gonna come in my court and tell me that he can't sit on death row until he gets judged and have his fair trial?
that opinion. And I read that, I guess, more particular to the botched execution attempt versus sitting there for decades and not knowing how and if it would happen.
No, but it was anxiety that was the underpinning.
Yeah, you was talking about how could he deal with the anxiety of knowing he might be going to, baby, how could his family deal with the anxiety of knowing they won't never get their loved ones back? But let her cook.
I don't mean to disrespect what Mr. Creech felt or went through, but you're talking about realistically from February 29th, if this was leap year, until now, and what you're talking about for Mr. Kohberger and what would happen if he were convicted and if he were sentenced to death would be decades. The court just acknowledged that it's decades to sit.
Well, I say
And no
a
disrespect to
decade,
the anxiety Mr. Creech felt. I think that must have been horrible for him. But to sit for decades and wonder is a lot longer. And so I understand what the Supreme Court said. I did read that too. But I think it's different when you're just starting out here in this circumstance.
Okay. Thank you. Aye.
Your Honor, I'll try and keep this brief. I don't want to repeat much what's in my brief, and I think a lot has already been discussed today, but I want to start by pointing out, one of the things that Ms. Taylor just said was, looking forward, we don't have the answers to that yet. Well, that's the whole point, is this just isn't right. We don't know what's going to be available decades from now, and it probably will be decades, plural. If you look at, Idaho's track record, Mr. Creech, Mr. Pizzuto, they were convicted back in the 80s.
Take as true, for the purposes of my question, that the state doesn't have a method. Should defendants be tried for and potentially sentenced to death when the state has no method of execution currently?
Yes, Your Honor, I don't see a problem with that, because deciding the method of execution is not deciding the sentence. The sentence is death. The method of execution is just how that's brought about. And so even the United States Supreme Court has recognized that someone who was convicted and sentenced to death, in that case, I believe was hanging. And then after he was sentenced to death, the state passed a law, made it electrocution, and the U.S. Supreme
Wait a minute. Wait a minute. Idaho a little bit rusty with their executions. Now, what we about to hear is they so rusty with the executions that the last time they even had to do one, it was a hanging. That lets you know right there, that's not constitutional. Ain't been no hangings in a minute around these parts. But let them build. Or as people would say, let them cook.
Court said there's no ex post facto problem with that, because you're not changing the penalty. The penalty is death. And so even if you assume that Idaho cannot do lethal injection, and even if you assume that the firing squad is unconstitutional, that's not to say that decades from now, there is not going to be a method by which the state could put him to death. And then, of course, I was accepting the hypothetical as proposed, but we would strongly push back on this idea that Idaho doesn't have a method of execution. There was a scheduled execution to take place on November 13th, just days from now, that was only stopped because the federal district court entered a stay so that it had time to consider some additional claims. But in that case, Director T-Walt put in an affidavit that said, we have the chemicals, we can do this. We've modified the procedure to address the individualized problem that came up with Mr. Creech before, and so we can execute Mr. Creech. So there really is just no evidence whatsoever to suggest that Idaho can't do this.
Whoa. So basically, the defense is saying, not only do we have a scheduled not only do we have a scheduled execution for November 30th. If I just looked at my calendar, that's a few days, y'all. I think that's Wednesday. He said the only reason that was postponed is because we just had to make sure we had the right chemicals, because it's been a minute. So if we doing chemicals now, then chemicals it will be. That's what I got from that.
And certainly not that it can't do this decades from now. And again, that gets back to the ripeness issue. Is it may be lethal injection, it may not. It may be some other method. But we just don't know enough now, frankly, to spend the time and the effort debating what we don't know in the future. That's the entire reason the rightness doctrine exists. I also want to speak just briefly on the Bucklew point that the court brought up. You know, what I'm hearing from the defense is they just have this kind of like vague Eighth Amendment assertion of maybe it's kind of the anxiety, but kind of not knowing how you're going to be executed. Well, that's not how the law works. There's an established framework of how you can make an Eighth Amendment method of execution claim. And Bucklew, the court specifically said, I'm quoting here, identifying an available alternative is a requirement of all, and all is emphasized in the decision, all Eighth Amendment methods of execution claims. You can't get around that by just saying, well, but I'm making a slightly different kind of claim. It's not a method of execution claim, it's a means of execution claim. That just doesn't work. That's not how the law operates. And so they haven't even suggested, even today, an argument what a proper alternative would be, which also gets back to the ripeness issue, which is we don't know decades from now what an alternative might be. Maybe they'll have a better argument decades from now on the method of execution because maybe there will be a better method. And that gets to the final point I want to bring up, which is the remedy here. They're asking that the death penalty be struck because these methods are unconstitutional, but that's not how it works. If you show that one method is unconstitutional, part of the reason you have to present a viable, readily implemented alternative is so that the state can then use that method for the execution. You don't get to, at the beginning, short circuit the whole thing and say death is off the table because the.
All right, I'm only going to pause for a quick second. I see we got new people coming in. This is not the trial. This is only a hearing that the defense want to make and say, man, listen, my client is not guilty. He's innocent. We're fighting for his innocence. But while we fighting, do my client have to sit on death row? That's what this whole thing is about. The actual trial will start August of 2005, and it is expected to last until November of 2025. Here on, we're looking at Bryan Kohberger, PhD in criminology, and also taught at Washington State University, was arrested at age 28, right? For the unaliving and burglary of 4 people. And that's where we at.
The current method is unconstitutional. As I said before, the method could change. And so if they came in and they had evidence and they could show that there was another method that's not lethal injection, that's not firing squad, that severely or significantly reduces the pain, and it's readily implemented, the answer isn't to strike it, the death penalty completely. It's to say, okay, you can move forward with the trial. We can see if he's sentenced to death, but you can't use those 2 methods to do it. If the state wants to pass a law and do the other method that he's proposed, then you can do it that way. So for all those reasons, Your Honor, unless there's any further questions, we'd ask that the court deny the motion.
Thank you. Any rebuttal?
2005.
Just briefly, Your Honor.
My apologies. The trial starts August 2025 and is expected to last till November of 2025. My apologies.
The distinction is not us being on death row with a death warrant that we're talking about. That's a different kind of conversation. We're well before looking at the overall picture and saying the Constitution protects somebody from sitting in prison when there's not a real means to execute.
Do you
I
have
understand.
any case that says that?
I'm making an analogy with the troop versus duels and the denaturalization with the dehumanization that happens if somebody sits on death row when there's not a realistic way to execute. I understand that lethal injection has not been overruled. I understand that. But when we're talking about the recent history of what's happened in Idaho, there are problems, and there are real problems. We talked about Pizzuto, we talked about Creech, we talked about 2 pieces of legislation to try to make this work, and it just doesn't work. So we're in a position where I'm not with a client that has a death warrant, and we're talking about whatever they'll probably talk about with Creech, with how they're going to do injection. We're not talking about the marksman involved in a firing squad. We're talking about way back here when we're sitting with constitutional protections, and Idaho's got all these problems with executing somebody. And how is that right, fair, any protection under the Constitution for somebody to have to sit there and just wait for Idaho to figure it out? That's the difference in our argument. That's it. Thank you.
Thank you. All right, court will take that issue under advisement and issue a written opinion with respect to its ruling. Next, I want to take up the objection to Professor Kohberger's testimony.
Your Honor, as the state pointed out in its written objection, Professor Kohberger's testimony is
Is it
largely,
Cover or Kohberger?
I believe, I'll defer to defense counsel. Is it? It's Cover.
Cover, thank you.
Thank you, counsel. Professor Kohberger's testimony in this case would largely center around a legal analysis that she conducted over several other murder cases throughout Idaho. Now, the first reason that this isn't appropriate is because legal conclusions are just not the appropriate subject of expert testimony. The state cited to Ybarra in its objection, and in Ybarra, the Idaho Supreme Court held that legal conclusions by an expert were not proper for consideration before the court. Now, that expert was allowed to testify as to factual conclusions, but the court struck legal conclusions from that expert's declaration. Additionally, as the state also pointed out in its written objection, the Idaho Supreme Court straight up rejected a similar attempt to do an analysis over first-degree murder cases in an attempt to argue that Idaho's statutory scheme doesn't accomplish narrowing. And so I think the court can look to the Hairston case.
Brandon, you say you've been following this case very close, so he's not convicted. Brandon says no, he isn't. This is a hearing for a pre-phase of the trial, which is scheduled for next year. Now, I did say that, but hold on, Brandon. Check. And being that he has not been convicted of the crime, he is still standing trial. So we're not going to argue that. And indicted and convicted is 2 different things. But he is indicted. He is indicted. It's all good. Let's get back to the content.
Where it was an almost identical argument, and the court found that it simply wasn't relevant, and also
Respect, Brandon,
Professor
respect.
Kohberger from testifying on that basis as well. When the state received the PowerPoint that Professor Kohberger would be utilizing, many of these slides are simply excerpts from statutes. The PowerPoint itself is titled An Empirical and Constitutional Analysis, and that's largely what her testimony would be, which is a constitutional analysis leading to her conclusion that Idaho's statutory scheme just doesn't accomplish narrowing. This is a legal argument, and the state would ask the court to preclude her from testifying on that basis. Thank you, Your Honor.
Massa?
Good morning, Your Honor. The first argument that I'd like to address relates to Hidalgo. And in the Hidalgo case, the state of Arizona had actually conceded that there were statutory problems. And when the Supreme Court took that into consideration, the reason that they did not issue a cert was that they wanted a robust discussion about other data analysis and have that come under the scrutiny of cross-examination. And so that's my first point to you today, is that the United States Supreme Court wants what we're wanting to accomplish here today with Professor Cover. They want that discussion to occur so that the data is and studies are scrutinized and discussed, and a trial court like you has the ability to make a full assessment. Reading a paper doesn't allow you to do that the way that the expert who did the study can explain it. The other point that I want to make is that as it relates to the Hairston case, I pulled the underlying briefing in that. So the underlying briefing in Hairston was a direct appeal and a post-conviction appeal, and they were consolidated. And the study that Dr. Jensen did was nowhere even close to what the study that Dr. Cover did.
But the court's thrust was that the legal analysis is not whether the statutory aggregators cumulatively narrow the class of first-degree murders eligible for the death penalty. That's not a relevant legal analysis. The legal analysis is whether an individual aggravator does so, that it excludes rationally first-degree from among first-degree murders within that particular aggravator. And as I understand Hairston, it's just not a relevant issue. It's not a legally it's not an issue that upon which the question turns.
Well, Hairston was decided
that I'm a trial court and not the Supreme Court.
And I'm sorry I interrupted you.
No, that's
Hairston
okay.
was decided in 1999, which was a long time before Hidalgo was decided. And so the United States Supreme Court has absolutely made the issue ripe and said, we want to hear what the specific data is, and we extend the invitation for that to be done. The study in Hairston was framed as, did Idaho's method of compelling financially burdened counties to bear the cost of litigation in capital cases result in arbitrary and
That
capricious
was the claim of
application?
geographic discrimination.
Pardon?
Wasn't that the claim of geographic discrimination?
It was based on money and whether or not an urban
That's
versus a
different from
non-urban.
the issue of what the relevant legal framework is with respect to whether or not the aggravators are overbroad or over-inclusive.
I
as a
agree.
whole.
I agree. But before we get to even there, Judge, which would come under our motions to strike, the heinous, atrocious, and cruel, and utter disregard, and propensity, the other motions that we have before you, we first have to focus on the eligibility and looking at eligibility of the death penalty in the state of Idaho, which is a legislative function that looks at the statute and then the aggravators as a method of narrowing, and whether or not that results in arbitrary and capricious application for purposes of the Eighth Amendment. And that's what Professor Cover's study addresses.
Correct. It doesn't address whether an individual aggravator is itself overly inclusive. It doesn't do it based on, in fact, she generalizes the aggravators as quote unquote the fuzzy ones, I think is what she called it. And then the, I can't remember what the name,
Clear.
the clear ones
Right.
were.
Right. But it is her study is a good foundation when you're get into the next level of looking at those aggravators and the definition of fuzzy and what that really means in terms of the analysis to strike those individually. So we have to begin with looking at whether or not we should even be getting there in the selection process.
Right. But I guess my concern is that the Supreme Court, the Idaho Supreme Court, has said that that's not the issue. when we look at whether the aggravators are unconstitutional as being not sufficiently narrowing of the class of persons or crimes available for the death penalty, the Supreme Court specifically rejected a approach that is based on the cumulative effect of the aggravators together. It said you have to look at each individual aggravator and ask, with respect to that aggravator, does it exclude sufficiently? Am I wrong about that?
I don't disagree with what your statement is. I'm saying that we've got to start before that with the analysis of who is eligible
Right, but that's
to
the
be
point.
charged with the death penalty.
That's
But it begins, Judge, with the definition of first degree murder. You start with the definition, which is very broad, of first degree murder,
which is why the aggravators are required.
right? And then you look at what happens within those aggravators. And we are arguing about the individual nature of those aggravators in other motions. So, these are different arguments.
But you, in those other motions, didn't rely upon Dr. Culver's article.
No, that's true, but it still comes to the issue. You still have to look at the issue of eligibility before you get there.
But the aggravator is the eligibility.
It's part of the analysis.
I see, Brandon, you've been doing extensive research. If you want, I'm gonna drop the link. I'm gonna drop the link for you if you want to come sit up here, say anything, promote your. I don't know if you have a channel, if you've been like, what are you doing this research for? But if you want to give the audience a quick spill of what you've been, doing, I'm gonna drop the link for you. It's gonna be in the chat. All you gotta do is follow the instructions and make sure you click out of YouTube once you actually enter the link so you don't get that feedback. And this link is for anybody who is on topic. The link is dropped. You can come and be a part of the show. That's how we doing it.
I mean, everyone agrees the statute itself as to first degree murders that are eligible is without more unconstitutionally vague. That's what.
And basically share your information. It ain't got to be a whole long spill because I know y'all want to get through this, but just share your information with the crowd, man. I don't mind that at all.
Why the court has U.S. Supreme Court then later approved statutory aggravators, including with judicial gloss, right? So then the question the court has said, the Supreme Court of Idaho has said, and the Supreme Court of Arizona has said is, and other courts, not whether, when you look at all the aggravators together, cumulatively, do those sufficiently narrow? The question is, when you look at an individual aggravator, does it exclude first-degree murders from it? Does it narrow first-degree murders? And you look at those each individually and not cumulatively. My understanding is that Professor Kohberger's analysis is that taken as a whole, these don't accomplish that. Is that accurate?
I would yield to her to testify to that, Judge.
Well, I've read our law review article, and that's what she says.
That's the purpose of having her testify. I think that it comes in segments, and you have to begin with the definition, then you have to get to the aggravators, and then you have to look at what is the quantity of cases in Idaho that fall within both of those, paired against what the result is for it being arbitrary and capricious. And when you're talking about our court, the Hidalgo case is from the United States Supreme Court, post-states what our court said in Hairston. The
other concern I have, I'll save that. I'm just now thinking about whether I need Dr. Cover. Why can't I rely on her law review article as a proffer of what her testimony would be?
Well, Judge, you are the trier of fact here, and it's important that you listen to, I believe, to make a reasoned decision, hear testimony, and hear that testimony be confronted and cross-examined. And that's what the United States Supreme Court said. I mean, if the state were to stand up here right now and say, hey, we concede, the statute's overbroad, the aggravators 11, everybody fits. What the United States Supreme Court has said is, we appreciate that concession, Arizona. It may genuinely exist, but we are a justice system where we want to hear that data talked about. We want to hear those issues confronted. We want to hear that debated. And so as a trial judge in this case, this is the appropriate time for you to hear that so that you can make a reasoned decision, not just based on her paper, but based on her explanation. One of the arguments that the state has made is that, we don't know what she's gathered, what her methods are. Well, she'll be able to testify to that, to explain that to the court, what her approach was. And it was different than what happened in Hairston years ago. And so for that reason, this court should hear that so that you can make a reasoned decision.
Your Honor, I'd like to address the foundation issue, because even if this court were to use the denial of cert in the Hidalgo case as a basis to delve into this issue at this time, Professor Cover's data does not provide adequate foundation to be reliable enough for the court to do that. And what I mean by that is that if you look at the Excel spreadsheet that was provided as an exhibit, I would direct the court's attention to just 4 examples. Line 22, the Nuxall case, death notice was not filed in that case. And Professor Cover did a review of the documents that were available to her and labeled that case as clear hack. Now, the significance to her designation as clear hack is that elsewhere, when she designates cases as hack or utter disregard or propensity, which she describes as fuzzy aggravators, she doesn't designate everyone as a clear aggravator. She only designates this one in particular and potentially others as clear, which then calls into question, well, are the others not clear? And potentially did the prosecutors who were determining whether or not to file death perhaps have more information available to them that enabled them to determine that, in fact, that those aggravators did not apply. The next I would direct the court's attention to would be the Huntsman case, line 33 in that spreadsheet. That case was labeled utter disregard / propensity ? Again, if Professor Cover can't determine for sure whether or not these labels apply and has to place a question mark in there, and she's relying on the court record, not necessarily the entire body of evidence that the state would have had before it when it determined whether or not to file that notice. Again, she isn't even sure herself, at least according to the spreadsheet, if those designations apply. Carlos Alonso Sandoval, line 44, her notes indicate possible hack. No death notice was filed, and according to that spreadsheet, it would have been included in her study. Yet she writes possible hack. And there was no clear aggravator in that case, I believe, Your Honor, which means that, again, we're including this case based on the fact that she's designating that it might apply, possible hack. Finally, I would point the court's attention to line 52, Angela Cervantes. The state did not file a notice of death in that case. Now, there was a clear aggravator, according to her, for kidnapping. But again, when she lists whether or not a fuzzy aggravator applies, she writes utter disregard with a question mark. Again, Dr. Cover is relying, according to her article, on documents she was able to obtain from transcripts from the state appellate public defender's office. She did not indicate in her article that she had, I don't think she even argues that she had the same body of evidence that the prosecutor would have had in each of those cases, making those determinations. So what's essentially happening, and this kind of brings us full circle to the legal analysis issue with all of this, is that she's reviewing court records, making a legal determination that's different than the prosecutor who made that determination whether or not to file a notice of death, intent to seek the death penalty. This is not a reliable body of evidence upon which the court could even make that determination, if the court even wants to consider it as evidence, which in the state's position, it's really just a legal analysis where Professor Cover is just reaching a different legal conclusion based on court records and providing a statutory analysis. And so the state would just argue that her article is a sufficient proffer. We would ask the court to grant the state's motion and to disallow her from testifying today. Thank you, Your Honor.
Thank you. Rebuttal?
Before they do this rebuttal, it sounded like it's like minimum evidence. That's crazy if they trying to put him to death with minimum evidence. Now, you can go on your own and look. It's a lot on this trial, but I can give you the summary. They didn't search his apartment till 7 weeks after these crimes. And when they finally arrested him, he was in his car, I think, on his way out of town with his father. This, again, is a man with a PhD in criminology. What would make him want to do crimes? Is it something that just intrigued him allegedly and made him want to commit these, or is he an innocent man? This hearing today is not to answer any of that. It's only to answer the question, will death penalty be on the table? Because at the end of the day, he took the lives of, allegedly took the lives of 4 innocent people while they were sleeping in their homes. And what's so crazy and interesting about this whole trial, how did he do it? We know it was alleged stabbings, but how could he work a whole house and unalive all those people and no one got out alive? Which only means one thing: he was calculated in what he was doing. Now, PhD in criminology could have assisted, but here's the even more messed up part if you just tuning in to this breakdown. He was also a teaching assistant at Washington State University. So here's it's kind of like a summary of what you're gonna get into come August when you hear this witness testimony. What do you think his professor felt like? You were seeing him hand his diploma and he bumped fists. That seems like a guy who really had a good relationship with his teacher. What do you think his teacher got to say now? Will his teacher testify on his behalf? We just have to wait and see.
Oh, actually, that was the rebuttal, wasn't it?
If you'd let me talk,
I will indulge you.
Thank you.
My schedule is already shot to hell, but we'll indulge you.
Judge, we will be able to get through in one day.
I wish I would try to talk to a woman like that. I'll indulge you. She was looking at me like, what?
I think that the argument that the state just made feeds my point, which is they're drawing conclusions off of the raw data without talking to the expert. When an expert provides their spreadsheets and has notes without asking Professor Cover what a question mark means, what the exact records were, why she used those records, why the conclusions she drew were drawn. First of all, you don't have the exhibit because it has not been admitted. It's been provided to them because they were raising issues about wanting to see the data. Or if she's allowed to testify, she can talk about that.
This is the data that she used with respect to her law review article.
Correct. To draw her conclusions and do her study. And so,
And that law review article was as of 2019?
yes, yeah, yes. And so I think that the state just actually made the exact point that I'm trying to make to you. Thank you.
So you, since I have you, you brought up Hidalgo, and you talked about the Supreme Court doing this. My reading of Hidalgo is that cert was denied. A minority of justices issued their own statement in which they thought it would be important to gather additional information. The court itself did not. Am I correct about that?
Well, you're correct that cert was denied, but Hidalgo has been viewed across the United States as an invitation. It's not just Idaho that's done this, done a study. You know, other states have done the same at the invitation of the Supreme Court.
An invitation of 4 of 9 justices of the Supreme Court.
Correct. It's still an invitation, and it's been accepted.
As y'all keep watching this, Jordan, I'm about to go and look for that right now, because if you telling me it was 2 additional people in that house and they didn't get touched, yeah, I'm gonna go get that while we listen to this hearing, y'all. I'll be right back. Y'all definitely do me a favor. I see a lot of people coming in. It's nothing to double tap the screen or just hit that like button. And if you're new to the channel and you liking the vibes, go ahead and subscribe.
As an invitation.
Thank you. So I don't find the proffered testimony of Dr. Cover will be relevant or helpful to the court to decide this issue. I think that I can rely upon her law review article and the data that I understand that has been provided today as a proffer of what that testimony would be. Of course, the constitutionality of Idaho's capital sentencing scheme is a question of law. Whether to allow expert testimony is committed to this court's discretion, specifically the well-known 4-part My Fun Life standard. Opinions as to the law are generally not admissible by experts. The court is the determiner of questions of law and not what somebody else's opinion of what the law is. Opinions of what the law is are received by the court through counsel, not through expert witnesses. And so generally I would not have permitted expert conclusions about the law. And therefore her opinions are neither relevant nor helpful, and therefore not admissible. Importantly, of course, as we've talked about, Idaho has opted to satisfy the constitutional narrowing requirements from the U.S. Supreme Court through the adoption of statutory aggravators rather than through narrow definitions of capital offenses. The relevant, as I understand from reading her article, Professor Cover's analysis is offered to support the argument that collectively Idaho's statutory aggravators do not sufficiently narrow those first-degree murders which would qualify for the death penalty. But that is not the question that the court must answer. The relevant question is whether
All right, y'all. We about to pivot. We about to pivot real quick. We about to see. Yeah, I found it. I found something. I don't know if I found it, but I found something. We're gonna pivot over there and we're gonna come right back. Here's what I found.
Three weeks later, more questions, few answers, no suspects, as friends remember 4 lives lost.
How truly special I felt to be your friend.
For the first time, we hear from the 2 surviving roommates inside at the time of the stabbings in their own words.
I'm going to be reading 2 different letters, one from Dylan and one from Bethany.
Their letters read by a pastor at a service held this weekend. From Dylan Mortensen.
My life was greatly impacted to have known these 4 beautiful people.
And Bethany Funk.
Maddie, Kaylee, Xana, and Ethan were truly all one of a kind. They all lit up any room they walked into and were gifts to this world.
Officials say the surviving roommates have been ruled out as potential suspects. Their 4 friends stabbed to death in the early morning hours of November 13th, likely while asleep in their beds. With no suspects or murder weapon, the Moscow Police Department still following leads in the investigation, digging through more than 100 pieces of evidence on top of thousands of calls, tips, and emails, maintaining the fatal stabbings were targeted. The department also focused on dispelling misinformation, saying there is speculation without factual backing, stoking community fears and spreading false information. But in this tight-knit town, frustration is boiling over. The father of one of the 4 victims, Kaylee Goncalves, is speaking out about the investigation to Fox News.
The lead detective looked me in his eyes. I have no doubt he's working as hard as he can, but somebody isn't communicating. There's nothing being released.
In our interview, he says with
I understand, Pop. I understand, Pop. He want to know everything on the hour, minute, second of the day if anything is found out about his loved one. And I'm sure and I'm positive he is not the only one. This case has gripped the nation, y'all. It's one of them. It's one of them. I think it deserves a reaction. What do y'all think? This is supposed to be the introduction. But judging by the people in the building, and y'all let me know if you really want me to cover it, hit the like button. Now, get me to 100 likes. Ain't no way. Ain't no way. But let's hear what the father had to say.
With a lack of evidence, he's terrified the trail could go cold.
I don't know how you catch a criminal if you don't even know what you're looking for.
Families now fearful they may never find justice. Steve Patterson, NBC.
What's crazy about this whole case? How do you catch a criminal when you don't know what you're looking for? And I'm pretty sure the last thing they was looking for was a Bryan Kohberger with a PhD in criminology. Now look at him, sitting here on trial. He was renting a 2-bedroom apartment through the Washington State University when he was arrested. He lived alone. His apartment was fairly empty and missing shower curtains, y'all. Now, that may not mean nothing, but the shower curtains did kind of interest me. Like, who don't have shower curtains? You know what I'm saying? Only people who don't take showers. Unless you just keep a towel, let's be honest, on the floor and just get water every time. No. What happened to his shower curtains, y'all? And out of 50 items that was tested for ballistics, 2 came back. I understand the father want all the answers, but you got to sometimes let the DA office cook. But the fact that they have him indicted is very, very interesting. And it's also very interesting that they have death on the table. What do the prosecution know that we, the people, the communities, the civilians don't know? Andrew, you heard me, bro. No shower curtains, bro. That only can mean one thing. He's guilty. He's guilty, but that's not how it works. He's not guilty, y'all. He's pled not guilty, y'all. And he's saying he's innocent. And how it works, you're innocent until proven guilty in the court of law. So let's get back to the content. If you're new to the channel, do me a favor right now. Before I get back to the show, and just double tap the screen, or you can go to those 3 dots on the screen and let's like the video.
It's we in the streets with it. These YouTube streets. Let's build it. Content after content. We on the block. Lego. And as a daily reminder, hit that like and subscribe so you can get the vibes. You know it. And notified every time. Let ride. It's sweet. It's sweet TV.
There are particular individual aggravator provides a principal basis for distinguishing between those who deserve the death penalty and those who do not. The Hairston case, I believe, makes that clear. The court is bound by binding precedent of the Idaho Supreme Court on this issue. Therefore, I don't feel the need to take Dr. Kohberger's testimony. I think the issue is sufficiently preserved through her law review article and the data that was provided. Now, if I look at this when I write this issue up, I certainly can invite counsel and Dr. Kohberger back at a later date to provide that information or to help clarify some of that information. From that perspective, I don't think Dr. Kohberger's testimony is needed this morning. Now, I'm not going to preclude the argument on the merits using Dr. Kohberger's analysis, because certainly counsel has the right to make a record of their argument on that as well. I will hear argument on the merits of the motion to strike the aggravators writ whole. This is not the argument on the individual aggravators, but on the collective aggravators.
We are asking the court to strike the death penalty because in Idaho, there is no narrowing of eligibility, which results in arbitrary imposition of a death sentence. We are also asking the court to strike the death penalty as a violation of the Equal Protection Clause. We will argue narrowing first. When it comes to the determination of eligibility, it begins with the definition of first-degree murder. And when the definition of first-degree murder is looked at, then the next thing that happens is looking at statutory aggravators. And the reason that those two things exist in Idaho and those steps in analysis exist in the United States is because of the Furman case. It's important to distinguish between eligibility to be charged and selection, which is at a post-conviction phase of a case. And so our argument and our focus for this issue is on the eligibility phase. What
your argument doesn't consider the weighing of mitigators against the aggravators is what you're saying, and the appellate review available. You're simply focusing on whether collectively the statutory aggravators narrow the class.
Let me answer the mitigation question first. Mitigation is in the selection phase.
That's what I'm saying.
So I'm not arguing about that. I'm going to step and grab my water.
Sure.
I want to be clear about the argument and eligibility that I'm talking about the definition of first-degree murder and the aggravator statute, because our definition is so broad that there is no narrowing there. And so that is an important first step.
Coco, you in here because something do not make sense about this. If they saying a witness seen a male leaving the house, then how is it that everything, I don't know, how did he choose the victims? Why was he there? That part does not make sense. If I was the defense, that's what I will be building on. How does he even know these people? Are they sure they got the right man?
Step that the prosecutor in their discretion, they're looking at, and there's essentially no guidance with the first degree definition. And so you do get to the narrowing factors, which is the duty of the legislature that cannot be abrogated to any other branch to fix when there is no proper narrowing. Professor Cover concluded that when you analyze those things with the 195 cases that she reviewed and collected data on against the number of death verdicts, which is so low, that you end up with a statistic that is worse than the statistic that the Supreme Court struck down in Furman.
Well,
And
so the Furman's an interesting decision, right? Because while I recognize two of the justices talked about those specific statistics, I don't know that those specific statistics are in fact a binding opinion of the court. There's much more in Furman apart from the statistics that two justices relied on.
And I don't disagree with that, but it's certainly guidance for the court. You know, if you're not, when you're not hearing testimony from the expert to explain everything that was taken into consideration in the conclusions that she drew, then what I'm going to do is take it at the high level that Furman is the guidance of those statistics. Her statistics show that Idaho's were vastly worse, and so it's certainly.
Ooh, hold on. I'm seeing y'all in the chat. I see y'all coming in the chat. I see y'all. Hey, let me read this one. It say they linked his cars to satellite information. This guy is cooked. How cooked is he? Huh? Is he rare or is he well done? Let me know. I see another comment right here real quick. It says his phone pinged off the tower right by their house at the time of. Ooh, won't it do it? Won't that cell tower do it? We just seen cell towers used in another trial we were just covering, y'all, that YSL trial. Cell towers can and will be used. Now, it was another one I said. They said the sheath. I think they meant the sheet. I can't find it right now, but somebody said the sheet had a brownish, reddish stain on it, and everybody know that's the professional way of saying blood. You know, is this actually happening right now? Yes, this is actually happening today, right now, y'all. This is live right now. But he must got some cash. He always clean suits, but clean suit. Yeah, so this is happening right now, man. If they got that DNA though, that DNA gonna make it. It's gonna make it stick. Let's be honest. I think the jury gonna look at that and say, yeah, ain't no way in the world his DNA was on a sheet in any one of those in that house, period. And he don't know them. If he knew them, if he was messing with one of them, then that'd be different. But the claims is he don't know them people. So y'all let me know. When this case first came out, I was like, what the heck? It ain't make no sense. And then I ain't hear nothing else about it. But he been sitting and he been marinating on the shelf. Allegedly the death shelf. Let's get back to the commentary. The students thing seems kind of familiar. Yeah, okay. It's been 2 years. Craziness nowadays. All right, y'all. Let's get back to it. Salute to everybody coming in. I see you. I think they are. Hold on, let me read his last comment. I'm gonna read user. That's a lie. Just a month ago, the professional expert testified that his phone was never near the house and that they were only 2 towers in the town. I'm not gonna lie, y'all. I can't hold everybody up, but this is what we are. It's looking like y'all want to cover this and get the live reaction. So it's one of them. It got all the ingredients for a good, lengthy, juicy trial. Let's see how everything pans out, and let's get back to the content. If you didn't already, subscribe to the channel. And if you want to put me in the algorithm, do me a favor, double tap that screen or go to those 3 buttons and get the likes up.
Something that the court needs to take into consideration in terms of whether or not there is the ability to narrow in the state of Idaho. The conclusion from the expert who did the study here is that there is no narrowing.
And my question was more a legal one, which is the analysis by Dr. Kover in her extensive law review article takes as its starting point that you have to have a statistic below that identified by the two justices in Furman.
Your Honor, I guess I disagree that that's where she draws a hard line there. I think that it's guidance.
Okay.
And there were other states that she looked at that she could certainly, if she testified, explain what was going on in all of the things that were going on in her analysis. But I don't know that my interpretation is that there's this hard and fast line, but certainly we have a line that the United States Supreme Court looked at, and Idaho's is worse. So the problem when you have no narrowing is that instead of it being a situation where the worst of the worst are being charged with the death penalty, everyone falls within that category. And that cannot be remedied by anyone else other than the legislature, because that is their duty. And if there's no narrowing, then and it's arbitrary, that's a basis for this court to strike the death penalty. There were, when Dr. Cover did her study, she looked at other states that did a better job of narrowing in statutory aggravating factors. And I want to give the court an example of what that looks like. In the state of Oregon, which actually is on pause with its death penalty right now, a narrowed statute there is the murder of two or more people or terrorism while in custody and after a previous homicide conviction, premeditation and against a child under 14 years of age, or premeditation and against a police officer or other officer. So that's an example of how a legislature can certainly make an attempt at getting factors much more narrowed and tailored. Now, Oregon's hasn't been, as I understand it, has not been taken up on appeal, so it hasn't been analyzed at this level, and the death penalty is on pause there. But it is an example of a statute that can be narrowed. The other thing that I wanted to point out is that the state of California versus Lipa, and I hope I'm saying that name right, has a statute for aggravators that in and of itself carries a whole bunch of mitigating factors for the state to actually take into consideration. So the state doesn't wait until it's very clear that the state is looking at what only happens in Idaho at the selection phase and not the eligibility phase. The other point that I want to make about our motion on this is the issue of geography. And I want to point out that we are arguing geography in the context of equal protection, which is a unique argument that has been made in Idaho and has not been addressed on appeal. When it was being raised in Harriston over financial resources, and the point was geography, it was in the context of arbitrary and capricious, and not in the context of equal
but
protection.
As I understand your analysis, is that the geographic, there's a predilection for capital cases to come from geographic centers of large populations, correct?
Correct.
client's case does not stem from one of those.
That's true, Judge, but this is not, we're not talking about the facts of our client's case right now. We are talking about Idaho's
Your claim
statutory
is
scheme.
on the whole, your claim is that it violates equal protection.
Correct. And not only on an Idaho level, but also on a national level, when you take into consideration how many states have stopped using the death penalty or paused using the death penalty. So it's geographical at a state level, and it's geographical at a national level.
Interesting. I think the last 3 or 4 death penalty cases have come from outside those geographic centers in Idaho.
In terms of the southeastern Idaho.
2 in southeast Idaho, and I recognize one was death penalty was taken off the table for reasons outside the control. Well, I suppose not ultimately outside the control of the state, but because of the state's failure in discovery. This case, another one up in the 2nd district. It's not all dreams. Resolved. It's not all bliss. You find your world is tumbling down. It happened to me. It happened to me. Once you find your world is tumbling down. It happened to me. It happened to me. Once you find your
Let's be honest. It's the biggest blogger on these YouTube streets breaking it down like this, y'all. It has everything. The commentary, the visuals, the chat. I couldn't do it without the chat. The subscribers every day, 200 or better subscribers. I can't make this up. The people who've been rocking with me, they can attest for that. It's over 500 people in the building going up and down. I know y'all can give me 100 likes. That's 20 more likes. Salute to everybody that hit that like button. If you're enjoying the commentary and you really feeling the vibe, go ahead and subscribe right now. This just the summary. We not even starting this case yet. The YSL trial next week. But how y'all feel about this one though? August 2025, this trial begins. The craziest, man. And let's be honest. This right here is in remembrance of Ethan, 20 years old. Zana, 20 years old. Maddison, only 21 years old. And Kaylee, only 21 years old. They had people that loved them. They was going to school being productive citizens of USA. Ain't no way justice will not be served, man, in this case, man. This is a sad case. This case has messed up a lot of people's lives. And I'm going to be breaking it down if y'all want me to. But go ahead and hit that like button. Let me see what my likes at. Come on, 6 more likes. Don't make me beg. I ain't going to beg. But I will finish playing this out, and then we're going to get back to the commentary. We can get the lights up some more. Went from PhD to penitentiary. Wow. What made him do it? Did he really do it? A PhD in criminology, it does hit different. Don't wait till it hit home. Because if it hit home, then it's too late. Be the difference in your community, man. Thank you for everybody that hit that like button. Now let's get back to the content. I appreciate that, family. I really do.
I can't dispute that. That still does not eliminate the fact that in Hairston, the Dr. Jensen concluded that there was a geographical issue, and in Dr. Cover's study, she made.
I'm gonna read this last comment because I did catch it. You'll see a lot of comments came in. Damon said, I believe he did it, but we won't ever get the reason why. Sometimes it be like that, bro. And something tells me that you out there. Something tells me that you even closer to this case than we will ever know. But that's just my feeling and my intuition. But it do be like that. Hopefully it doesn't end like that. If he is found guilty, hopefully he's man enough to have a statement of, reflection of why. And that's only because he's not guilty yet, y'all. He's only been indicted. But let's be honest, we don't know what they got. If it's some type of way to find out that a guy with a PhD in criminology performed these crimes, it kind of just make you think. Let's not even go there, man. Let's just get to it.
Observations about geography as well.
But even she's confessed she couldn't make any conclusions based on that.
And that was why I used the word observation. And had she testified, she would have explained her observations regarding that. But it is instructive to see that a study that was conducted in 1995 in Hairston has the same results in 2019, even if it's just an observation about geography. One of the things that the Supreme Court mentioned in its decision in Hairston is that they really wanted more information about the data that had been gathered and the reasons that there was a determination by Dr. Jensen regarding that and more analysis. But nonetheless, that was Dr. Jensen's conclusion, and they are Professor Cover's observations. For those reasons, we are asking that you find, based on Professor Cover's study, taking it at face value with its conclusions and providing you with the data that we will look at and redact
If
names.
I go there, in other words, if I accept that there's an actual valid analysis to be done here, would you agree that I need to look at cases since 2019 as well?
I think, Judge, that the point of bringing in an expert today to talk about a study is that that's her expertise in gathering the information and putting it into a compilation. For you to engage in that on an individual basis.
Well, I can't take her opinion because it's a legal conclusion. Looking at her data, which is 5 years old now, it seems to me that if I were to engage in that, I would have to look at the data as of today and not as of 2019.
Yeah, I guess I'm not willing to concede that. And if it was something that, needed to be undertaken, I'd like to have the opportunity to have Professor Cover testify about
She's
her
got no
time
opinion
frame.
about that.
Pardon?
She's got no opinion ultimately about that. She has some data that she collected that she thought was interesting and might require some additional study. I guess the point is that if I were to engage in that, it seems to me relevant, at least as to the state claim for, claim that the state equal protection, not the state equal protection clause, but the equal protection as applied within Idaho geographically, would need to look at that as of the time frame now.
Well, it could certainly be instructive, Judge, but if you're taking the data from Hairston, which was 1978 to 1995, and Professor's covers from 2002 to 2019, you know, the data, if it was analyzed, I'm quite certain would support both of their premises. I haven't analyzed it. You know, we could have that study done, but I think that there's enough guidance with all of those years of data to be able to draw the conclusion that it's arbitrary and capricious today, because the statutory language is still, the definition is still the definition. The statutory aggravators are still the statutory aggravators.
I have a case that indicates that an equal protection analysis can be applied on its face as opposed to as applied, because my understanding is an equal protection clause has to be analyzed as applied.
Yeah, I'm not able to, I can't right in this moment give you that case. I'd be happy to look into that and submit it as a supplemental authority.
You would agree if it is as applied, that would put your client's claim, at least as it relates to within the state of Idaho, as not being problematic, given that he's from one of the smallest districts in the state.
Well, then I want to go back and talk to you, Judge, about the premise in Hairston, which was pre the Capital Defense Fund, which also has created, you know, in time, another dynamic of whether or not someone's charged with the death penalty and those costs at the time that he was charged. I mean, now it's different. So yeah, I'm not going to concede that as applied, it just simply doesn't fit. I think that there are greater questions than that, but I don't have a case to point you to exactly. I don't think that has been, it hasn't been raised in Idaho. We're making the first equal protection. I mean, in other district court cases in North Idaho, Mr. Logston has raised this issue, so I don't want to say you're the first.
All of those.
Right, but it has made it to the Idaho Supreme Court, to the appellate courts.
I just don't see how, as applied, you've provided the court any information where I could conclude that, because your client is from one of the geographic districts you claim is the does not get its fair share of capital cases.
And we did not submit that argument in our brief.
All right, thank you. I think you've used your time.
Yo, not the smooth dismissal. Thank you. I think you used your time. Wow.
Thank you, Judge. I'll try and keep this brief. I think there are two problems, independent problems, with the theory that the defense is articulating here, and they both come from Idaho Supreme Court decisions. The first, as this court has noted, comes from Hairston, where the court said this just isn't how you do the analysis. You don't accumulate them and then do
What's
the analysis.
intellectually wrong with that analysis, though?
With accumulating and then
I mean, I understand the legal cases may not be supportive of the defense's claim, but from an intellectual analysis, if the point is to make the death penalty less arbitrary,
correct.
Why wouldn't you look at the net or the cumulative as opposed to each individual compared on its own in isolation?
So, Your Honor, I think to answer that question, you know, looking back to kind of how this was developed with the aggravating factors, the idea behind the aggravating factors is that you have to be able to show that this person is morally worthy of the death penalty. And so if you have individually analyzed every single factor and every single one you found constitutional, then it doesn't matter if in every case you could apply one of those factors, because that factor is a reason why that person is morally worthy of the death penalty. And so it's not an arbitrary and capricious system. It's not left to the whims of somebody. It's
But if you have so many aggravators,
Worthy? So the death penalty is a good thing? Even though they're saying even if you put to death, you still got to spend at least 20 years of your time before you get put to death. That was if you came in late. That was the whole spill about it, because they talking to Idaho like Idaho don't know how to execute people. They thought Idaho was rushed. They say last time Idaho did an execution, it was by a hanging. And the only things they got on the table right now is lethal injection and death by a firing squad, which some would say may be offensive to the Eighth Amendment. But let's go.
That on the whole would essentially apply to any first-degree murder. Then isn't it just left essentially to the prosecutor as to which cases are or not worthy to bring as a capital case?
So absolutely, the prosecutor would have a lot of discretion in that. I don't know that I agree with the characterization that it's left to the prosecutor, because of course the prosecutor has to prove that aggravating factor beyond a reasonable doubt. And if they can prove one of those aggravating factors beyond a reasonable doubt to the jury, and the jury finds that, then that person is now worthy of the death penalty. And again, you know, when we instruct the jury, we don't instruct them to consider all of the aggravators in the aggregate. We tell them you have to consider them individually. We tell the state's required to present non-duplicative evidence for each aggravator that it's going to assert. It can't just throw out a blanket of aggravators. I think focusing on single aggravators is consistent from beginning to end of our entire system. And so I don't see a problem with that analysis that the Idaho Supreme Court said that that's not how you do this. And I would note, I think the court has mentioned this as well, it's not just the Idaho Supreme Court. There are many courts who have rejected this approach. The defense hasn't been able to point to a single court in any state, in any jurisdiction, that has used this cumulative approach to attack the death penalty or the statutory scheme of the death penalty in any state. So I think the court was right in Hairston. Clearly it's binding precedent. You know, the defense in their reply brief, they tried to say their response to Hairston was, well, that was when judges were doing the determination. And I just don't see the relevance to that, logical or otherwise, how that would matter on the narrowing part. They point to Hidalgo, which they brought up multiple times today, which is a dissent. It has no binding authority. It has no effect whatsoever on the case. So they just can't point to anything to say that Hairston doesn't apply today. It does apply today. And the Idaho Supreme Court has rejected that approach. So that's the first reason why this fails. But then even independent.
I hope y'all don't mind, but I have to. He's talking a bit. We're not going to overlook what he's saying. We're just going to speed him up. Speed him up.
Of that, there's a second reason, and that is the defense is relying on this narrowing process that has been described by the United States Supreme Court. I believe the most recent case that they've kind of walked through that was the Tulipa case. And in Hall, our Idaho Supreme Court talked about Tulipa and exactly what that test requires. And they were analyzing a single aggravator because that's how you do this. And it was, the court acknowledged that, yes, this would apply to many, many murders, but it doesn't apply to every murder. And that's all that Tulipa requires. So the way, even if it were appropriate to aggregate all of these circumstances, the appropriate narrowing question is, does it literally apply to every single murder? And even Professor Cover's analysis shows it doesn't. It's a high percentage, but it's not 100%. And so it would pass the narrow requirements of Tulipa as interpreted by the Idaho Supreme Court, even if it were proper to aggregate these together. Your Honor, in terms of the equal protection claim on geography, I think, you know, here again, they run into a problem with the Idaho Supreme Court. A similar claim based on geography was raised in Hairston.
That would have to do with the cell tower evidence. He represents the state, if you just tuning in, and the defense is seated and rested right now. They was a bit long with it, so they should rest.
And the court rejected it. The court not only rejected it, the court instructed future defendants, if you want to bring this claim, here's what we're going to need to see. And they said, in order to show that the imposition of the death penalty in Idaho is arbitrary and capricious, there must be some empirical evidence connecting the discrepancy that appears to be shown by Dr. Jensen's study and one or more impermissible factors. And the defense has been aware of that. And instead, they bring a study where the person who conducted the study acknowledges, I can't show that. That it's just not sufficient. It's not sufficient to make any kind of, at best, they've shown a statistical discrepancy, and that is not sufficient to claim some kind of constitutional violation, any kind of constitutional violation. I want to end just by talking a little bit about the court's question on, would you have to look at the data up to today? I think the question or the answer to that has to be yes, absolutely. There's no reason why the date Professor Cover conducted her study has any legal relevance or significance. It would be up through today. And I think this goes back to a problem of this whole accumulating the aggregating factors and then doing a mathematical study and finding a percentage. Because let's say that courts engage in that conduct, and let's say that courts decide it's 50% is the magic number, and if you get above 50%, then your statutory scheme's unconstitutional. Well, what if Idaho is right at 50.5%, so it's unconstitutional, but then over the next year, a bunch of murders are committed and none of them satisfy the aggravating factors. So now we're at 49.5%. Now everyone in that year can be subject to the death penalty because the murderers that committed murders that year decided to do it in a way that didn't satisfy one of the aggravating factors. I don't think there's a logical basis for that. And I think that's why the Idaho Supreme Court has taken the approach they have, where this isn't a quantitative analysis, it's a qualitative one. Is there any narrowing that's being done? And if the answer is yes, then you've passed the test. That keeps things fair and uniform across the state and temporally across time. And so I think that's another reason why it wouldn't make sense to aggregate these. Unless there are any questions, we'd ask the court to.
You want to address the geography issue?
Yes, Your Honor, I addressed it briefly. I'm happy to talk about it more from the Hairston decision.
It's not necessarily a requirement you do so. I just wanted to know, you were fairly summary about it. And it seemed to me the defense had raised some issues that.
I'm gonna tell y'all one thing I noticed about this judge off the bat. You can tell he's well seasoned. He's been doing it for a long time. And even when you think he's not listening to what you're saying, he be listening.
Perhaps were a little more expansive than what they had argued in their brief. And so
I would certainly agree with that, Your Honor. So a couple of things on that. First, the idea that it somehow violates equal protection for Idaho to apply the death penalty when other states do not on a national basis. I'm not aware of any case law that would support that. And in fact, it's directly contrary to the case law that we're going to talk about later on evolving standards of decency, where the U.S. Supreme Court has specifically acknowledged that, yes, there are some states that apply it and some states that do not. The conclusion from that isn't that just because there are some states that do not apply it, it's unconstitutional everywhere. So I don't think that that's an appropriate question. In terms of within the state of Idaho, I think to the court's point, with an equal protection analysis, really the first question you have to ask is, who are we talking about? And what status do they have, or what position do they hold? Because a critical part of the equal protection analysis is you have to treat people that are similarly situated the same. You don't have to treat people who are not similarly situated the same. So that initial determination of are they similarly situated requires a subject, a person. And so to the court's point, I think in the vast majority of cases, at least that I'm aware of, equal protection is raised as an as-applied challenge, as applied to the person bringing the challenge. So in this case, where they're trying to argue that it's only the larger counties that seek these things, as the court pointed out, that's not true in recent Idaho history. And
Let me put this all in layman's terms, because attorneys they get paid to use big words. In layman's terms, we don't care if the big cities do the death penalties. We're gonna give him death, and it's gonna be on the table because allegedly he has been indicted for 4 murders, y'all, in one. It's a 4-in-1, and if he is a PhD, and if he has a PhD in criminology, and he also was teaching criminology, this is a disgrace to the PhD that he had, because he wasn't supposed to do these crimes. He was supposed to uphold and teach the law, man, not tear it down and misuse it by taking what he learned and possibly applying it to allegedly his maniac mind, man. And now they're trying to say, well, it isn't right that he should be facing this and have that emotion to deal with while he stands trial. He should be able to be a regular person. He shouldn't be on death row. But the state saying, we don't care about all that. It ain't about the evidence we got. It ain't about if we're a big city, if we're a little city. It's about the fact that we believe this man is guilty, and we are planning on proving it in the court of law without a reasonable doubt. Because ain't that how justice is supposed to work? He have to get proven innocent without a reasonable doubt. Now, we heard a few things. They talk about geography. That means wiretaps. I mean, not wiretap. That means cell towers, and how basically your phones and cellular devices interact with cell towers. They plan on using that. They talked about DNA evidence, having doctors come and basically tell the jury how they went about the analyzing of the information and testing the evidence that they did find. I don't think they would have picked him up if they didn't have any evidence and indicted him. But again, innocent until proven guilty.
They, again, have not pointed to any study, Professor Covers or anywhere else, that shows that the reason why there are more death penalty cases brought in the larger counties is because of some unconstitutional reason, rather than, could it be explained by something else, like the fact that they are more appropriate in those areas. And frankly, the common sense understanding would be that you're probably going to see more death penalty cases in more populated areas, because just as a matter of statistics, there's probably going to be more first-degree murders committed there, and therefore probably more that are eligible for the death penalty. So certainly they would have to rebut that with some kind of evidence that shows, as the Idaho Supreme Court told them they had to in Hairston, that makes a direct connection between empirical evidence and some impermissible factor. And that's just missing here. Unless the court has any other questions. Thank you, Your Honor.
Rebuttal.
Judge, I just wanted to touch on the issue that he raised about Hairston and the timing of that, and the fact that at that time when that came down, judges were doing the imposition of death penalty sentencing. And that really is a very important distinction, because as you know, the arguments that are coming up in other motions, the difference in an experienced judge being able to get into all of these nuanced areas and apply beyond a reasonable doubt in the gateway phase, and then just mercy in the mitigation phase is very, very different than a jury's ability to do those things when it's the only case that they're looking at. So I do think it's important to take into consideration the timing of where we're at now with the jury decision. The other thing is, I just wanted to point out some of that mitigating language that I'd referenced in Tulepa that's in the statute that we don't have. Whether or not the offense was committed while the defendant was under the influence of extreme mental or emotional disturbance. Clearly not something that's in Idaho's aggravating statute.
I almost kind of believe he was under some mental kind of disturbance, because how many of y'all, be honest with me now, how many of y'all in the chat listening to me right now do not have shower curtains? I repeat, how many of y'all in the chat right now have showers but no shower curtains? And no, I'm not talking about the ones who got the glass, the fancy with the glass you see through. You ain't got curtains, but you got a shower. I'm talking about the regular folk who got the shower bar with not the curtains hanging on it. Because I know y'all started trolling. But for real though, man, like, come on, y'all.
To consider whether or not the victim was a participant in the defendant's homicidal conduct or consented to the homicidal act. Whether or not the offense was committed under circumstances which the defendant reasonably believed to a moral justification or extenuation for his conduct. a statute that, you know, frankly, those types of terms in our statute would be very welcomed. And I wanted to also point out that the study dates amount to between 75 and 95 years in Hairston in 2002 and 2019 for Professor Covers. That's 37 years worth of data with the same definitions. So, you know, instruction in a few more years of data, you've got 37 years to rely on. There's no narrowing. Thank you.
Do you know what year the Capital Defense Fund was established?
It was after 95, and I think that.
Oh, he wanted them. He wanted them, y'all. He wanted them. I told you, gotta watch this judge. He's not no joke. He's asking a question that he already know the answer to, which is ultimately a lesson for this attorney. Let's go.
Hairston may have been the impotence for that. If Mr. Logston was here, he'll be here later. I think he knows the exact year of that. But I don't. I just know it was after 95.
Issue in your mind?
Pardon?
Has that mitigated the issue in your mind?
No, I think that it has not. It has not. And I frankly think that the new system with the state public defense is going to make it worse. I think that there will be no reason for the state not to charge death in every first degree case, because our statute doesn't prevent them from. Everybody fits. Everybody fits.
Thank you.
Mm-hmm.
I will take the issue under advisement and issue a written opinion. It's 10:30. I'm going to take a 10-minute break, and we will re-adjourn after that.
All rise.
Mm-mm. Don't worry about it, y'all. Don't worry about it. I got you. I ain't gonna lie, y'all. Y'all shock me every time I hit the button. You're not gonna believe this. Some people gonna think I'm capping. But don't y'all know over 250 subscribers just in the time that I've been alive on live right now with y'all? I call it alive. Yeah, that's what I call it over here. But yeah, I appreciate that, man. I appreciate those subscribers, and I appreciate everybody that hit that like button. You dig? You ain't have to do it. So I want to let y'all know that I do appreciate it, man. We've been going up quite fast, and it's kind of mind blowing, but I accept it. I accept it. Let's keep going. He over there looking stiff.
All right, I think we are on now the motion to strike the individual statutory aggravators. I will give each side 25 minutes, and you can address them in whatever proportion you like.
This is what the YSL trial needed. See, he set limitations. He giving each side 20 minutes, which so he already know he can do 20 minutes apiece and still have a little bit of time for him to talk and in between. So his like every hour that he's accounting for is accounted for. I like this guy. I'm not gonna lie. Let's see who go first. Look like the defense going first with her 25 minutes.
Okay, Judge, I will be covering heinous, atrocious, and cruel utter disregard, and then I will do multi-murders, and Ms. Taylor will do future dangerous. So I'll basically do the next three, and given the time that you've asked, I'm assuming there will be less questions.
I will try to restrain my curiosity.
Right. I'm happy to engage with you.
If I, as you know, I gave you some additional time, and that says why.
Right. Thank you. We are asking that the court strike the aggravator, especially heinous, atrocious, and cruel, manifesting extreme depravity. And I want to focus, I think I just want to start really focused on how this is different than Hall. You know, we're aware that Hall, Arabay versus Levitt, there's a lot of discussion about having addressed this aggravator before. We are framing it for you in our argument in a different way. And so what I want to show, or the distinctions, is that, you know, Hall was a decision was issued in 2018. So was Hidalgo. So when Hall issued their decision, the arguments hadn't been framed in light of what we just argued about Hidalgo and that eligibility narrowing. Also, there was no equal protection argument, no argument regarding Article 2, Section 1 of the Idaho Constitution. One of the cruxes of this argument is that what the Idaho Supreme Court and the Idaho courts do with this aggravator is they've created a jury instruction that is construction, also known as, and called in our briefing, judicial gloss. Our argument is that Osborne is from 1981. That's when the judicial gloss was applied, and then recently the Idaho Supreme Court adopted and adopted instructions related to this. But what happened in 2011 is that the Idaho Supreme Court issued the Verska versus St. Alphonsus decision, and in that decision, the court said, this court has consistently adhered to the primary canon of statutory construction that where the language of the statute is unambiguous, the clear expressed intent of the legislature must be given effect, and there is no occasion for construction. And the courts have not taken that into consideration. So if the statute is unambiguous, then it should be given its direct meaning, which we quoted in our brief, would be heinous means utterly odious or wicked, atrocious means horrifying, wicked, and cruel means willfully causing pain or suffering to others or feeling no concern about it. And if it is ambiguous, then under Verska, the judicial gloss should not be allowed.
If it is ambiguous?
If it's unambiguous, then the judicial gloss should not be allowed. But what, the state is arguing that it is, has not argued that it's an ambiguous statute, because that would give us grounds for the argument that it should be stricken from as an aggravator as arbitrary and capricious. And so we are asking that you take into consideration the way that we are framing this argument, which is different than it was in Hall.
Ambiguous and vague.
Pardon?
Difference between ambiguous and vague.
I don't know that I can necessarily draw just a distinction there. I think that they're, similar. Yeah.
Well, so let's do all of yours, and then we'll do all of theirs. I think it goes faster that way. If we do this back and forth, I think it takes longer. They can take notes.
So utter disregard falls under the same argument. The one thing that I want to point out about utter disregard is that Idaho is the only state that has that as an aggravator. But when you look at other states, there's language that is found that is the same as heinous, atrocious, and cruel. which is interesting because it looks like almost we have the same aggravator labeled as two different things. And we also raised the argument there that it's a separation of powers violation when there is construction on that statute, and that violates VRSCA. The next one that I am going to cover is the multi-victims aggravator. Idaho is the only state that has both a multi-victim and propensity aggravator. A multi-victim aggravator is clear. We were having that discussion between clear and fuzzy. Multi-aggravator is clear, 1 + 1 = 2. The irony in some of that is that it seems to lessen the value of a single human life, but it still doesn't tell us anything about the culpability of the person who has been charged with the crime.
Well, isn't it more culpable to kill 2 people than 1?
I think that the issue is, the problem is that it is.
Isn't it a morally more problematic, the number of lives you take?
I think that it depends on, first of all, I want to start answering that question by saying any life taken.
I agree. And
Right.
And the floor is pretty high, but what I'm saying, doesn't that bring you above the floor?
I think that it depends on the underlying facts of what is the result, what's the basis of how multiple occurs. And so just to say that the number of people relates to culpability, I think that what the argument that we're making is that supports the other aggravator of propensity. And under Idaho's the method of selection with a jury and rules about double counting, while the jury can take into consideration the same facts for multiple aggravators, there must be more than one fact per aggravator so that there's not double counting. And that is the problem when you've got a multi victim aggravator and you also have a propensity aggravator. And there's been, as we cited.
Is that a constitutional problem or an evidence problem?
It becomes a Eighth Amendment constitutional problem when a jury has an inability to properly distinguish between those issues in finding aggravators beyond a reasonable doubt.
I mean, as the gatekeeper, I assume that if the state hasn't provided additional evidence that would support propensity that is not included within the multiple murders, then that aggravator wouldn't go to the jury, right?
Well, I mean, we would hope that the gatekeeper would do that. Yes, Judge, we're asking you to be the gatekeeper now and prevent us from even getting to that question because of the problem that is identified. And we provided the court with law review articles where the issue has been studied about how impactful multi-victim facts are into the ultimate decision regarding aggravators. I also wanted to point out that there are multiple states with a multiple out of aggravator that have that multi-aggravator, but they don't have future dangerousness, which Ms. Taylor will talk about, and that is very related to propensity. And those states are Alabama, California, Kansas, Montana, Tennessee, and Utah. And in fact, Texas is a good example of, it's a part of the definition of capital crime, and then the jury has to decide on the aggravator of propensity after that has been included as part of the narrowing in the Texas statute. So for those reasons, we'd ask that you strike the multiple aggravator as well.
Your Honor, we're asking the court to strike the aggravator of future dangerousness or propensity, whichever label we want to put on it, but it's found in subsection I of 1925-19, subsection 9. And I think when we're thinking about the constitutional way this is out to be protective of the Eighth Amendment, to have a true narrowing, and it can't be vague. We've been talking about that all day, so I won't go into that again. But with that in mind, I want to read the words of this aggravator for the court. That the defendant, by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. That language does nothing to narrow. That, I'll skip right to the vague part of the argument. We're asking the court to consider three things in striking this aggravator. It isn't narrow, it's very vague, and it doesn't go to the culpability of the crime that's been charged and, if this happens, convicted of. Your Honor, this language, I think, has been acknowledged by our Idaho Supreme Court as needing the gloss in Creech. And I would say that what's required is that the statute, which Idaho doesn't have, has to provide the narrowing, or the sentencing structure, and those things are legislative processes. And that hasn't happened. We have the gloss from the Supreme Court. Gloss that the Supreme Court has put on this, though, does not do anything but loop us back to the statutes that define murder and then exclude voluntary manslaughter. If truly we are to have an aggravator that selects out the worst of people who have been convicted of murder, this does not do that. The language in this aggravator is incredibly vague. When you think about really what is going to happen in front of a jury, they're going to get all this evidence that is supposed to be proven beyond a reasonable doubt. I trust the court will instruct them on that. But then they get this evidence that probably will make them believe that person's a future danger. The chance for a jury to misunderstand the call and the burden that needs to happen is really great. By the language alone, and Creech really doesn't do anything to help. The gloss that gets put on, the jury instruction that gets put on, doesn't help. That just says people.
Hall say that it was okay? I can't remember if they addressed that in Hall. I think
Hall did say it was okay.
So what am I to do about that?
You are to listen to that, allow me to make my record, which I am, but you are to say nobody else has talked to me about the real language in here when it says probably. That is confusing to a jury. This isn't a judge's call any longer, but this is confusing to a jury to have those words in there. And the chance to find this aggravator, either based on one of the other aggravators, which we know cannot happen, or at a lesser burden because of the word probably, you're to find that is way too vague. And you should strike this aggravator because of that. Additionally, while we're talking about vague, there's a lot of potential for the jury to misuse mitigating factors and make them into future dangerousness aggravators. And I think
that the truth, the possibility always in sentencing? I mean, one man's aggravator is another man's mitigator. And I think you pointed it out well in your brief of mental health, right? But isn't that the nature of individualized sentencing and the consideration of those factors?
I think it is a danger. And I can't square in my mind how I am to do my ethical duty to my client and to abide by the guidelines that are set forth in capital cases and do an investigation into mental health and then turn it over like Idaho says I must, and then subject my client to the state's expert to grill him for however long. I mean, I have this duty. My client has the right to present this. But now I have to do all of this and give all of that information up So the state can use it in an aggravator that says, just tell me that the person will probably be dangerous in the future. That is just terrible, Judge. And for that reason alone, you should strike this aggravator. The last comment I'll make is that future dangerousness doesn't go to the conduct, the culpability of the conduct that has happened. And that's really what these aggravators need to do to narrow properly the scope of who's who. I can't tell you the number of times I've sat in court and listened to a prosecutor talk about at sentencing that my client or my client's acts are the worst they've ever seen. And that can't be true when you sit in court day after day after day and you hear that about person after person after person. This statute doesn't do anything to help a jury decide who's the worst of the worst. This aggravator absolutely has to be struck. It's a violation of the 8th Amendment.
Thank you.
Your Honor, beginning with the heinous, and atrocious, and cruel, this aggravator specifically has been upheld by the Idaho Supreme Court, and specifically the judicial gloss placed on this aggravator in Osborne.
Was
Now,
Hall a jury determination? You know?
I'm not sure on that, Your Honor, off the top of my head. I apologize.
I think it was, but I don't recall specifically. Notwithstanding the fact that I think that I'm the actual judge on the case now, I don't recall because that issue hasn't come up. But
Thank you, Your Honor. And I apologize. The defendant has raised this argument that in Verska, the Idaho Supreme Court's decision stating that the court would not rewrite or void an unambiguous statute is essentially the same thing as stating that the Idaho Supreme Court is saying that we can't put a gloss on a statute. But those two things are very different, because placing a gloss on a statute to ensure its constitutionality is not the same as rewriting or voiding a statute. If Verska is taken to that extreme, then courts can't interpret statutes at all. And that's not the holding of Verska. Verska simply stood for the proposition that the court was declining to rewrite or void a statute. And of course, the Idaho Supreme Court has never rewritten the heinous, atrocious, and cruel aggravator or the utter disregard aggravator or any of these aggravators. They've simply placed a judicial gloss. As to the future dangerousness and propensity one, which was the most recently addressed, that too has been upheld by the Idaho Supreme Court in State versus Creech. The propriety of considering future dangerousness has been upheld by the United States Supreme Court in Jurek versus Texas. In their propensity argument, their future dangerous argument, the defendant is essentially asking this court to start with a proposition that a jury is not going to be able to follow the court's instructions. And of course, we can't start with that proposition because juries are presumed under Idaho law to follow the instructions that they're given. And that is another issue. That issue is also true in the defense's multiple victims argument. Their argument with multiple victims really doesn't cite to any case law. It's simply based on the fact that they're assuming that a jury is unable to distinguish between propensity and multiple victims. And again, the court is being asked to start with the presumption that a jury won't be able to follow the law. And that's contrary to the state of the law. We can't presume that because juries are presumed to follow the law. Additionally, we also can't start with the presumption that the state is going to just put on the same evidence for all these aggravators. The court should also assume that the state will put on an independent basis for each of these aggravators during the penalty phase. That's our legal obligation. And the jury will be instructed as to what the law is. They'll be instructed that they can't double weigh or double count. That's very clear in the case law. The state would just ask that the court decline to presume that the state will present the evidence in a way that's contrary to law and that the jurors then won't follow the instructions. That can't be, Your Honor. So the state would ask the court to deny the defendant's motion as to these aggravators. All of these aggravators have been upheld, specifically the hack along with utter disregard and future dangerousness. There is case law directly on point that is binding on this court. We would ask the court to deny their motion.
Thank you.
Judge, to answer your question about Hall was originally sentenced by a judge, and then the sentencing was retried, and Mr. Chastain and Ms. Christensen handled that case.
My memory came back to me between then and now, so thank you for clarifying that.
Yeah. I want to point out that Verska says, if it's socially or economically unsound, the power to correct is the legislatures, not the judiciaries. If it needs fixed with construction, as we argue that it does, it must be stricken. And I want to address the question that you asked about why not wait until the evidence comes in and I can strike the aggravator at that time. It goes to the point of why we are arguing all of these right now. There's a huge difference between picking a death qualified jury and a non-capital qualified jury.
Well, but that just went to my point of your argument presumes I would strike all of them. If, for example, I were just looking at multiple murders versus propensity, and those two so overlap that you can't have both, you could still have one, or you could have both. But if there's not evidence independent of one, then you would strike the one.
So you're correct that we are asking you to strike all of them so that we don't have to pick a death qualified jury, because death qualified juries are highly likely to convict in the guilt innocence phase. So we are very, very concerned about that, and the fact that that is so different in a death penalty case. But to the extent that you might strike some and save one, for example, the multi-aggravator, there's a vast difference in what happens in front of the jury in the selection phase with that aggravator versus the others that we are asking you to strike. Thank you.
Thank you.
Your Honor, I certainly didn't mean to tell the court that I would presume whatever jury we end up with won't follow the law. What I'm saying is that that particular statute, the future dangerousness statute, is really tricky. It's tricky because of the use of the word probably. It's tricky with the rest of the wording too, and based on the information that will likely come in. I point out that when it was up to a judge to decide, I think a judge is well versed in what does beyond a reasonable doubt mean and what is a probability. The court looks at that all day, every day, and those are hard concepts for a judge.
Standard would be that the jury would have to be convinced beyond a reasonable doubt that it is probable that the defendant would be likely, or is probable that they would kill again. I think it's the way that washes out.
I think that's the way it washes out too. And I think it's just a problem with the word probably in there. So when a judge was doing this, it was less of a problem, but I still think there's issues with that particular aggravator. And I would point out that the higher courts in Idaho have recognized the problem. That's why the decision in Creech put a gloss on it. And I think when the courts recognize that that's a problem and there needs to be a gloss or a fix put to it, that's one thing for the court to consider. How the fix was done, I think, is a problem. It's a jury instruction, not by the legislature. But keep in mind, there's a problem with this instruction or with this aggravator. It needs to be fixed. But the fix is to loop back to statutes that already exist. And I don't really think that's a fix. And I'll stop there.
All right, I think the non-statutory aggravators is the next issue for our attention. So with that, I'll hear from defense.
Thank you, Judge. Your Honor, by way of housekeeping with the non-statutory aggravators, I understood the state's response briefing to say that they agree that they have to provide notice and any discovery about non-statutory aggravators as well.
They said that they would, is what they had said they would.
Yes. So I think I don't have to argue about that. I think I'm limited to arguing about the burden of proof required for non-statutory aggravators.
Arguing for the defense, for the state on that issue?
Yeah, Your Honor, the state's position is that the statute clearly says that Rule 16 applies. We agree Rule 16 applies and we'll comply with Rule 16.
All right.
I'll limit my comments then to burden of proof. Your Honor, our position is that non-statutory aggravators need to be proven beyond a reasonable doubt as well. We know that the state can use non-statutory aggravators to help them establish aggravators beyond a reasonable doubt. And looking at the court's new jury instructions that just came out, beyond a reasonable doubt is all over those. When we're talking about aggravators, there's no question there. Those jury instructions are silent on non-statutory aggravators. So I can't lean on those to say that the court should find that these have to be proven beyond a reasonable doubt. But from a fairness standpoint and from a it just makes sense standpoint, you should say they have to be proven beyond a reasonable doubt. I'm thinking about this in the context of having a jury and having the prosecutor producing evidence and arguing beyond a reasonable doubt, but having these other non-statutory aggravators and say, these are things that we have that you should consider, but we don't have to prove these to you beyond a reasonable doubt. I think there's a real danger in a lack of confidence in the finding of an aggravator if you don't require them to prove the non-statutory aggravators beyond a reasonable doubt, just like their statutory aggravators. Capital cases are a really big deal. And if we're going to get all the way to the end of this, and that's where we're at, the court has to have confidence in what's presented to the jury. Mr. Kohberger has a right, if that's where we end up in his case, to have a jury finding any single aggravator they might find beyond a reasonable doubt. And we think you should order the state to meet that burden if they're going to present non-statutory aggravators.
Thank you, Your Honor. I want to start by just, I tried to be very careful in my brief to refer to it as non-statutory aggravating evidence, because I'm not sure what a non-statutory aggravator is. I want to be clear, the state's under no impression that there's some shadow list of aggravators that it can prove one of those and that qualifies the defendant for the death penalty. We are, of course, required to prove beyond a reasonable doubt one of the statutory aggravators. And I think what we're talking about here is just non-statutory aggravating evidence. So evidence that may not be, and if I'm being...
So if you look at like a scale, right? And defense puts on evidence of mitigation, and the state has to put on at a minimum evidence beyond a reasonable doubt of a statutory aggravating evidence. When you go to weigh, does your non-statutory aggravating evidence go on the scale when that weighing is done?
Yes, Your Honor. And I think that that's clear from the Hall decision when they talked about this. they talked about they talked about the Zant decision from the United States Supreme Court and how it's important that juries understand when they're making that, when we get to the individualized determination of is death appropriate in this case, it's important that the jury have a wide array of information. That's the purpose of the statute, is what the Idaho Supreme Court said. So yes, I think at that point, any aggravating evidence that has been presented goes on that scale. Now, to be candid with the court, in my mind, anything that's relevant to a statutory aggravating factor isn't non-statutory aggravating evidence because it's relevant to the aggravating factor. And just to be frank, I can't even come up with a good example of what the state would put on in this case that would qualify as not relevant to an aggravating circumstance, but relevant to the overall weighing process. I guess my point is I don't know that this is going to be an issue, given that we will, of course, comply with discovery. We will provide everything that they'll know what we're going to say before we say it. And if there's an issue, we can raise it at that time and discuss, is this actually relevant to a statutory aggravator or not? And if not, does it fit into what I consider to be a very narrow category of non-statutory aggravating evidence that is still somehow relevant to the overall decision, but not one of the aggravators?
I think the visual using my scale would be to get on the scale, the statutory aggravating evidence would have to have been proven beyond a reasonable doubt, right? That is, you have the existence of that aggravator would have to have been proven beyond a reasonable doubt. As I understand the non-statutory aggravating evidence, the existence of that evidence would need to be proven only by a preponderance of the evidence. Is that your understanding?
You know, I don't know that I would completely agree with that, because I don't know that that's laid out in the instructions that it's to any specific burden. I think if you look at the jury instruction 1722 on jury deliberation, it talks about finding the statutory aggravator beyond a reasonable doubt. And then when it gets to weighing, what it says is you must each decide for yourself whether all mitigating factors presented when weighed against each statutory aggravating circumstance proven by the state are sufficiently compelling to make the imposition of the death penalty unjust. You do not have to unanimously agree upon what mitigating circumstances exist. The existence of mitigating factors need not be proven beyond a reasonable doubt. You must each decide for yourself whether mitigating circumstances exist, and if so, then consider them in your individual weighing process.
Right, those are the mitigating.
Correct, but I think what I'm getting at is that's what we have in terms of the instructions of this weighing. Is it's saying to the jurors, you're going to conduct kind of an individual weighing process to decide whether it's just or unjust in this circumstance. And that's the point where these things would come on scale, to use your analogy. And so I just don't know if there's a point where you would instruct the jury, you know, you heard from witness X, they said A, B, and C. You can only consider that if you find that A, B, and C is true beyond a reasonable doubt. I don't see an instruction for that anywhere. I don't think that's typically how you do sentencing. You know, they would put on their mitigation. Maybe we have some rebuttal to that mitigation that you might consider non-statutory aggravating. But then again, it specifically tells the jury you do not have to find mitigating beyond a reasonable doubt. So my point is, both in the mitigating evidence and in this non-statutory aggravating evidence, there isn't a standard that's given to the jury. And I think that is what was intended by the instructions. And we could debate whether that's the right call or not, but I think that's what the statute calls for. I think that's what the instructions call for. And I think that's the process that we should follow. Recognizing, of course, this court's role as a gatekeeper to what gets heard at all. The fact that we'll be complying with the rules of discovery and they can bring up any objections that they want beforehand. I don't know that this will be an issue in the case. Unless there are any other questions, we would ask that you deny the motion. Thank you, Your Honor.
Your Honor, I would start by saying I thought I heard the state get really close to saying they're not planning to produce any non-statutory aggravators or non-statutory aggravating evidence, whichever way you want to talk about that, which might be really good. It might save the court having to make the decision if they get all the way there. I would say, though, there's not a statutory list of non-statutory aggravators, but in Hall, it talked about That decision talked about things in a person's background, if they had a prior criminal history, things about their character. And a prior criminal history, that's fairly definitive. Either you have one or you don't, right? But things about a person's background, that's where it gets really questionable. Are we talking about people's opinions, people that maybe would have an axe to bear with the person that they're talking about? So I think that when you consider what Paul talked about as a non-statutory aggravator, it becomes really important that the state have the burden of proof of beyond a reasonable doubt for those. I would just close by saying that Gardner versus Florida talked about why we have notice and that reliability matters. But it's the same thing on this kind of information, this kind of evidence, these kind of non-statutory aggravators that get produced. It has to be reliable, and the court has to be able to rely on what a jury comes up with. And Mr. Kohberger has a right to have information come in fairly, to have notice of that information, and for the state to carry the burden. And they need to carry the burden if they want to present non-statutory aggravating evidence. Thank you.
Thank you. All right. You're okay with it. I'm going to swap 8 and 9, just because I could see 8 potentially going a little bit longer than 9. And so, well.
Your Honor, can I help with that?
Yeah.
If the court takes the first part of 9, the speedy trial issue, that's the one I'm handling. And I think we've got Jay that's ready on the rest of them. We can cover it, but he's really close.
So he's not here. All right. Well, let's start then with 8, contemporary standards of decency.
That's the one that Mr. Logston
He
would
is.
be here. I've got Speedy.
Do you have, who has trifurcation?
Jay is the one that's the most prepared on trifurcation.
So you've got Speedy. Let's start with that then.
I can do that. Thank you, Judge. Your Honor, we're asking the court to strike the death penalty in this case based on a conflict of constitutional rights and Mr. Kohberger having to face the choice between holding on to one constitutional right at the expense of another. And that's what's happened here. He has had to choose between his 2 constitutional rights, and those were effective assistance of counsel or speedy trial. Mr. Logston wrote the brief on this, and he did a really good job with the history and why we should look at Idaho's speedy trial, constitutional guarantees of speedy trial in the same time frame that the statute 1935-01 says. I'm not going to go into all of that again, because really this is about the choice of picking between constitutional rights.
It seems to not to go into the history that your argument essentially asks the court to equate what the pre-constitutional statutory standards were as then constitutional standards. And I think the court has said that that's not the case. Am I wrong about that?
I'm not sure I'm following what the court's asking me. I'm sorry.
It seems that you're asking the court to equate what the statute said about speedy rights for the Constitution, Idaho Constitution provided for it, and treat that as the constitutional standard and grafting it into the constitutional standard.
I would say that it's there to provide guidance, because there was that the statute we have now is after the Constitution. The territorial statutes were before we had the Constitution. And when Idaho wrote its Constitution and said, we guarantee defendants a right to a speedy trial, there was that already in mind. I don't think our Constitution says it's 6 months to the day and it's over after that. I don't think that at all. But I think that what was a speedy trial would have influenced a speedy trial right. I do not think our Constitution says it has to be 6 months, but I think our statute does now, and our statute derived from an older statute. And I think that statute, well, I know that statute predated our Constitution, and I think it influenced the writers of the Constitution to, as a guideline, as a limit. We also know that speedy trial you can go beyond the statutory time frame, and you can stretch that out in different circumstances for different reasons. And our argument is less about that. That's not the argument. The argument is the choice that Mr. Kohberger faced in August of 2023, when he had to choose to continue his case, thereby giving up his speedy trial rights, or go to trial on October 2nd of 2023, 10 months after being charged with this case, with completely unprepared counsel. And that's really the crux of this argument. And the remedy is for the court to strike the death penalty because Mr. Kohberger had to choose between rights, reinstate Speedy, and reset a sooner trial date. That's the remedy. I want to talk about what happened and why Mr. Kohberger had to continue his case. The court's already heard a little bit today about the duties of counsel in a capital case and the kinds of investigations we must launch immediately. It's not just about the facts of the case, but it's also about the facts of the case. But the mitigation phase has to be launched whether or not you ever end up with a conviction. That work has to be done. That's the way it works, and it takes time to do that. You have to find experts, you have to find records, and it takes time to do those things as well. So, and discovery can be a really big deal, and I think the court is probably starting to understand just how big of a deal that is. Last August of 2023, when we were in that place where we had to make that decision, and there was a scheduling order from the prior court in this case that told us you have to continue it by this deadline, by this date, or you can't continue it and you're just going to go to trial. So I think we're positioned a little bit differently when we are truly in a place we have to give up one right to have another right. Had Mr. Kohberger gone to trial and stood on that right, his speedy trial right, and lost his right to effective assistance of counsel, there would have been more than a year's worth of discovery that his counsel would have not been able to know about. We have continued to get discovery. I think there's a bit more that continues to trickle in even past the deadline. I'm not arguing about that right now, but it's just a vast amount of information that Mr. Kohberger would have not had counsel prepared for. We do not have a mitigation investigation completed. We're in process with that still, a year and 2 months after that deadline. So he would not have had that to benefit him either. I think one of the most important things the court should think about when we think about Mr. Kohberger having to choose between his constitutional rights is that we're here right now because he couldn't get a fair jury in Latah County. And if we'd gone to trial in October of 2023, he would have maybe held on to his speedy trial rights. Well, he would have held on to his speedy trial rights, but he would have given up his right to effective assistance of counsel and his right to a fair and impartial jury.
What's wrong with the idea of speedy evolving on a sort of good cause basis? I mean, capital cases at the time the Constitution was adopted were tried within 6 months, right? The standards of how to try those cases were obviously different. And as more contemporary thoughts about that have arisen, it's become the standard that they require more. And so why wouldn't Speedy be flexible to accommodate that?
Well, I don't know why it would or why it wouldn't, but that's not been what's happened. We don't have a separate criminal rule that says that. We don't have a separate statute that says that. We would bend the Idaho Constitution until it breaks to make it say that. I'll give you kind of an example, during the time of COVID, when the Supreme Court told the speedy trial rights, it did that based on a national emergency. Court orders were issued. I am not saying whether I agree or disagree with that, but that's something that happened. And I think one of the cases the state cited in its response brief, State versus Ish, I think that particular case had 422 days of time between when the remittitor was issued and when the case went to trial. And that person asserted their speedy trial rights that whole time. That happened during COVID, when the court had its emergency orders during that whole time. So I think to say, well, it's a capital case and they're a lot different than they used to be, and they are, and they're a lot of work and they take a lot of time and investment. They do. But there's nothing that's been changed in our Constitution, in a court rule, in a statute to say if it's a capital case, speedy trial, really, you just don't have that right. A person facing the death penalty just doesn't have that right. All of those rights exist. They all exist right now. And Mr. Kohberger had to choose between those rights. And I think the court can and should strike the death penalty in this case based on the record.
That would
here.
result in the death penalty being struck in every case.
Your Honor, if that's the way it is, because our clients collectively in the state of Idaho, when you have a capital client, if that's the case, then that's the case. I mean, we have been doing
The Constitution is flexible enough for the Supreme Court to itself say, well, we can pause that right, and we can expand that right based upon the circumstances, i.e. COVID. Why can't it expand the time that speedy is measured by constitutionally, given that evolving standards have required more time to present a capital case and measure it against that?
I would say that I don't know whether they can or they can't, but they have not. And that's the critical area. I would say the Supreme Court probably would believe it could do that, but it has not done it. And I would say they would believe that they could because they did so during COVID. But that hasn't happened. That has not happened.
So you think that the Supreme Court would likely say, well, as opposed to interpreting the constitutional right more broadly to apply over the more flexible, given how the defense of capital cases have evolved, they would be more likely to say, well, we're just going to not have any capital cases, period.
I don't know if they'd say that or not.
Well, that's what
But
you're asking me to say.
I'm asking you to say that. I'm asking you to do
My job
what
as a district judge, if there's not an issue that has been decided by the court, to determine how that court would decide things.
Well, I think you can consider what Judge Boyce did. And
My apologies. I was out, so I wasn't able to pen any of the comments. But let me just say to Michaela comment, being a college student in Idaho, it does hit different where this is where you at. Currently, I think it's ridiculous to take the death penalty off the table. Everyone was shocked and horrified and scared when this happened. And I mean, let's just go over the facts and what we know about this case so far. I got a poll going. Y'all definitely participate. We got over 400 people in the chat right now. Let me know if y'all think that this trial is pretty interesting and y'all want to hear full coverage on it when that time comes. And that's 2025 of November. Now, here's what we know. The crime was at the University of Idaho, was 4 University of Idaho students who were stabbed to death on November 13th of 2022 at or around 4 a.m., allegedly, right? The victims' names being Ethan Chapin, age 20 years old, Xanax Kernodle, being age 20, I'm just gonna say the first names. Maddison, age 21, and Kaylee being 21 as well. Here's the suspect on trial. Defendant Bryan Kohberger, 29 years old as of now. I believe he was about 27 or maybe 28 when he was arrested. Has a PhD in criminology and also teaches as an assistant at Washington State University. So this is somebody who's actually teaching the kids. This is unheard of in the history of, well, I ain't gonna say unheard of, but this is crazy. All right. Here's what we know. The trial is to start August of 2025 and is expected to last around November 20th, 25. Okay. Let me see if I can get these pictures on the screen. Shout out to everybody at over 300 subscribers during this live, y'all. And I appreciate that. I really do. I really do. Now, let's get to a few of the facts, and I ain't gonna hold y'all long. Okay, so 50 items in Kohberger's apartment were picked up, right? But here's the thing. They didn't do a search on his apartment till after 6 weeks after the murder. It does hit different. 6 weeks after, a lot can happen, right? But when they conducted this search, they did find, out of 50 items that were tested for DNA evidence, blood, specifically of the 4 victims of that house that I just showed y'all, was found. They tested in that apartment. Only 2 tested positive for brown reddish stains, which is also known in the professional, well, that's how you say the professional field, but to regular people, we call that blood, right? And that was found on a pillow, and he had also a stain on the mattress pad. We don't know. No one knows if that matches up to any of those victims. But what is been mentioned during this case, that a sheath was left on the crime scene. It was a sheath to a knife that was left on the crime scene, the knife missing. The same knife that was probably and allegedly used to unalive these 4 young civilians who was only going to school to educate themselves. And let's be honest, this is just messed up. And I do hope they get justice for the families and the victims, because you should be safe when you lock your doors. You should be safe if you lock your doors. But even if you don't lock your doors, you should still be safe in your home. In this case, this home was burglarized and 4 people lost their lives. 2 people in the home unbothered, unscathed, and they got to live with this on their consciousness. So that's just the full breakdown of what's going on right now in this case. And y'all definitely hit that poll. Let me know. As far as the leather sheath that was left on the bed in one of the 2 bedrooms where the murders took place. All right. Kohberger was indicted in May for 4 counts of first-degree murder and 1 count of felony burglary. All right, y'all. You got it right here, man. It's Sweet TV. If you didn't already subscribe to the channel, let's get back to the content.
The Vallow case, and that had to do with discovery that counsel didn't have enough time to review and to prepare for, and it would have disadvantaged the client. And so Judge Boyce in that case struck the death penalty.
That was as a result of the state having failed to provide the information, violating its court order. And then the remedies were, well, do we push trial back or not? And the choice that Judge Boyce gave the defendant was, well, we can go to trial, but I'll remove the death penalty because a lot of the discovery related to that, or we can continue the trial for you to review that. But so So you can either go to trial with the death penalty, without the death penalty now, or you can expand it with the death penalty. One defendant chose one and the other defendant chose the other. In this case, the decision to waive speedy is not as a result of, as I understand it, a violation of a court order by the state.
It was as a result of a court order. And when we waived speedy, we advised the court and counsel that this motion this day was coming. We don't think it's appropriate to force somebody to choose between competing constitutional rights. Lori Vallow had not ever waived speedy trial. And so she had the choice to waive speedy or not face the death penalty. And we think that since we were forced to choose between rights, those should be reinstated and the court should strike the death penalty.
Thank you.
Thank you, Your Honor. So not only can the Idaho Supreme Court do that, it's already done it. The Idaho Supreme Court has said that we interpret Idaho's Constitution for speedy trial the same way that the federal Constitution is interpreted under Barker. There's one exception that has no application here. And so it's an individualized test based on 4 factors, and you're really looking at kind of the overall reasonableness of the delay. I would direct the court specifically to the Langford case that just came out last year. The Idaho Supreme Court walked through the difference between the 2 constitutions, explained how they operate, and then found specifically in that case that they charted out how many delays they were, what the delay was for, who caused the delay, and then was it reasonable or not. And they found, they said, in sum, most of the delays here were precipitated by Langford's own actions. In the case of the last and longest continuance, the delay was reasonably necessary to allow new prosecutors and new defense counsel time to prepare for trial. So they found that's a reasonable, under the Constitution, that is a reasonable delay. So there is no choice here. You don't have to choose between speedy trial or effective assistance of counsel. You can have both. I think what the defense is saying is they've lost.
I'm sorry, y'all, but this comment right here, this comment, Michaela says, I think tearing down the house was a bad decision, but a ton of people were going to the house, taking pictures of it outside. The families and city began to feel that it was treated like a tourist site. I wanted to put that and pinpoint that because it goes to, like, it's kind of a reflection of the day and the times that we are living in. The people has been so desensitized to death, to loss, to that it's shameful. Quite honestly, it's shameful that people do not consider the feelings of other people. And when, again, I always say this on my channel, when it hit home, well, man, that's when it's too late. You don't want to wait for it to hit home to understand these grievances. So that's crazy that the house is tore down. The house that it happened at, let me bring up the picture real quick. This house right here is no longer there because people was coming to the house taking pictures of it like it was a tourist site, while people still grieving and didn't even get justice for the people who lost their lives inside that house. But it's just the days we live in.
Their statutory right to 6 months, which they do lose if they take an action to delay the trial at all. But that's not a constitutional problem that they have to give that up if they want to maintain their constitutional right to effective assistance of counsel. Now, in this case,
well, and that was my point in perhaps not well stated, is that it seems what this defense is trying to do.
No, Tab, I'm not racist, but what's the meaning of what? What's the meaning, baby?
Was the territorial law, which is that a case had to go to trial within the, at that time, courts were held in sessions, calendar sessions, right? I think there were 2 sessions a year or something like that. That was the speedy right. And then we had the Constitution that doesn't necessarily give us such a fixed time frame, but the argument is, well, because that was the territorial law at the time, therefore that's the constitutional right, and it is engrafting that statutory construct to mean the constitutional right.
Potentially, Your Honor, though I'm not sure that's exactly, because my understanding of the pre-Constitution statute was that it was based on kind of the circuits and when they came, and we don't do that anymore. And so that time frame just doesn't make sense today. You wouldn't be able to just
That's a
engraft
good
that in the
question.
Constitution and apply it today, because
My point is,
Quick, it's too early to say if he would admit guilt. Somebody said that earlier, though. Being that this guy has a PhD in criminology and he also teach in a university, I'm not gonna say he's smarter than a lot of the people in the room. I'm not gonna say that, but I will say this: if he did these things they saying he did, for his soul, you will hope, and that's only if he did, he would admit it. But I don't think he will. I think this is somebody who has a type of fetish maybe of doing and teaching it for so long. It's just, and watching all, it's a lot of things going on in this world. I'm not gonna give y'all my opinion. Let's get back to the content. How about that?
is that's, I think, what the defense is arguing, essentially.
yeah. Yes, Your Honor, but the statutory right they're pointing to comes from the new statute that was passed in 1980 that gives the 6-month time period, and regardless of whether they want
Argument that the 6-month is functionally equivalent of the twice-a-year circuit.
if that is the argument, I don't think that it gets past the Idaho Supreme Court has said, no, it's not. So, under the Idaho Constitution, we use the Barker test. The crux of the matter here is that the defendant didn't have to waive his constitutional right to a speedy trial. He did so under advice. He did so in writing. He did so knowingly, but he didn't have to. The trial could have been continued, even at his own request, without him waiving that right. He waives it statutorily by moving for a continuance or to ask for more time to prepare, but he does not waive it constitutionally. If he did, then most of this Langford analysis would have been completely unnecessary. But instead, at the end of the day, when you do finally get to trial, the reviewing court looks back and breaks out segments of time and says, whose fault was that delay? And as the court said in Langford, many of the delays were because of Langford, and so they don't count against the state. But the court easily could have said, well, he asked for a delay, so his constitutional right was waived. They didn't, because that's not how it operates. So the real problem here, I think that the defense is grasping with, is that they didn't need to waive his constitutional right, but they did. So, there's not much the state can say other than that wasn't required. The Constitution not only can be flexible, the Idaho Supreme Court has held that it is in fact flexible. And one of the reasonable, a proper reason for delay is to prepare for trial. And that means this is not a choice that has to be made by any defendant. It didn't have to be made by this defendant, but he chose to. Unless there are any further questions. Thanks.
Just briefly, Judge, we're not trying to graft in a time into the Idaho Constitution. We're looking at the word, the guarantee for a speedy trial, and trying to figure out what the word speedy means. And so,
Well, doesn't speedy mean the Barker test?
at the time the Constitution was written, I don't think it did.
But isn't that what the Supreme Court has said it means?
I think our Supreme Court does agree that it's the Barker
Again,
test.
I think I probably can dispose of a number of motions by simply saying that the defense asks me to do X. Doing X would violate the binding precedent of the court. Denied.
I think if I was here saying dismiss the case based on a speedy trial violation, I think that's exactly what the court would do. This is a little bit different. We're asking for the court to set the case back to the point where we had to choose between constitutional rights and to strike the death penalty. In our case, this is the last point I'll make. In our case, we signed a waiver of speedy trial And it was a form, I believe, that was generated by the court. It was signed on August 23rd, 2023. Mr. Kohberger signed it, and I assigned, with the parentheses, attorney for the defendant. And in that form, and remember, our scheduling order said you have to do it by this day, or you don't get a continuance, you're just going to trial. We gave up the right to, under the United States Constitution and the Idaho Constitution. And I have a printed copy, but I know the court probably has the entire court file. That's it.
All right. That, along with the other motions, will be taken under advisement. Let's take a lunch break. It's 5 to 12. Adjourn at 1 o'clock. Thank you.
All right. I got the poll going in the chat. Do y'all want to cover this trial come November 2025? I mean 2025. I don't know why I keep saying 2005. It's over 300 people still in the building. I apologize. I keep saying November, y'all. The trial starts in August of 2025, and it's projected. It's only projected. It's not promised, but it's projected to go until November of 2025. I stand corrected. Now, in this live, we just basically did a briefing. I began the live with one of the roommates that used to live in the home with the students, and then we also looked at a quick clip of 2 additional students that actually were in the home during the alleged killing. Now here's the thing. Going from what we know, it had to be quick. It had to be without too much of a fight, because how could you work around? How do you even go into a house? Because here's the thing, y'all. Here's what I want to ask y'all before I speed up. What makes you even bold enough to go into a big dwelling unannounced, armed with only a knife in 2022? That's when it happened. Knowing kids, and people have weapons, guns. Maybe whoever the culprit was, but they saying it was him. Maybe he did have a gun. Maybe he was well armed. But let's be honest, everybody was stabbed to death. And that's just crazy to happen. When it first hit, it was crazy because it was like, people were just confused. No motive. Who would come and break into somebody's house, unalive multiple people in the house, and then leave the house undetected? But we would come to find out that they was detected. Now, they saying a sheath was left behind with blood on it. They also saying that they got geography, which means cell towers, basically, tapping and pinging off of a cell tower close to these students' house. All right, we almost at the end. All right, so we queued up.
It would simply.
So we queued up on that. Now, what the poll looking like? 89 votes. Hit the poll. Let me see what the poll saying. Poll saying, yeah, cover it. All right, say no more. Yeah, say no more. Let's finish out this proceedings for the day. I'm not gonna lie, this judge, I feel like he's gonna grant a speedy trial. It's only one defendant. It shouldn't take more than, I think, 3 to 4 weeks. But it might take longer because it's 4 individual cases of murder. So they got to build a case and they got to build a foundation on each one of those. So that might be why they got that 90 their trajectory on that. Let's get to what happens after lunch. If you're new to the channel, hit that subscribe button, and if you didn't already, hit that like button. Over 300 subscribers. I can't worry about what a hater's saying down there. You hear me? I appreciate everyone that hit that like button and everyone that subscribed to the channel. Let's continue. And big shout out to Michaela, man, because you out there. So anybody that's out there, you know, big shout out and big salute to you. It's had to be crazy for the city. And I know y'all watching it the closest.
Your brief says otherwise, so that's why I question that, because as we've learned, that takes a long time for those things to be developed. That's not necessarily evidence in the pocket of the state. What is now gone from a case timeline of several months to now multiple years would seem to me to even drag it out longer.
And I certainly understand that concern. I don't think that that's position. I certainly do believe that the law would require the state to put on mitigating evidence if it had it, because that's something that they're required to do by law. They're required to put on evidence, if known to them, would possibly point in the direction that the person is innocent, et cetera. But I don't think what our position is that the state would be required to put on essentially their entire sentencing hearing in front of that grand jury. The grand jury is still only just determining whether or not there is a reason to go forward with the case. Our point is that at the time of the founding, that grand jury would have known that all felonies lead to the gallows. So at that time, grand juries were making decisions about whether or not people were going to face the death penalty. And it wasn't until the Supreme Court after Furman in the 70s that we came up with this entirely new system. But it's one where the grand jury has lost its part of its function, where it's looking at whether or not these people should be facing the death penalty or not. Essentially, they were deprived of that through the transition that was obviously intended to protect people from an arbitrary infliction of the death penalty. But the grand jury itself is supposed to also have a role in that. It's supposed to protect people from arbitrary decisions. And so that's essentially what our argument is that there should be a neutral fact finder placed between the citizen and the state when we're making the decision whether or not the death penalty should be sought. And so that is one of the reasons we're asking the court to strike the death penalty in this case. Does the court have any other questions for me? Thank you, Judge.
Your Honor, sounds like on Abdullah, this is just a issue of issue preservation, so I don't have much to comment on that. In terms of this other argument that they are saying you can look at it differently through the Eighth Amendment, keep in mind the Eighth Amendment is just the prohibition on cruel and unusual punishment. It's quite a stretch to jump from there to requirements on what needs to be presented to a grand jury. The Beck case that they cited suggests that maybe there could be a connection if that diminishes the reliability of the sentencing determination or the guilt determination, but that's not the function the grand jury plays. And so for this court to stretch the Eighth Amendment all the way back to the grand jury would be.
In fact, with respect to failings of a grand jury to pass on a particular element, for example, if there's then been a trial, the general standard of appeal is, well, the matter went to a jury and they made the determination there's proof beyond a reasonable doubt, and therefore any error is moot.
Correct, Your Honor. And I think really that gets to the heart of this claim, which is it's just kind of another way of their argument that it shouldn't be the prosecutor deciding that a notice is filed. And the U.S. Supreme Court has said it's not a problem if the prosecutor has unfettered discretion in who gets the death notice and who doesn't. So that by itself isn't a problem. So unless there are any other questions, thank you, Your Honor.
Thank you. Any rebuttal?
Well, I I think it would be back in a case involving a possible death penalty and being able to put a stop to it then and there. And so I do think that the Eighth Amendment has the ability to attach even that early on, at least in cases involving death. And then I recognize that there are these cases from the Supreme Court indicating that prosecutors do not have to have anybody determine whether or not they can file the death penalty and that they can drop it out of a sense of mercy. I think that's a slightly side question to, if they choose to go forward with it, who can stand up and say, before we spend years on one of these cases, that this is not the appropriate case, someone besides the prosecutor, which is what we have with grand juries and preliminary hearings, et cetera. And so we still believe that the argument here is one that can be passed on by this court and that hasn't necessarily been ruled on by these other cases that we also think should be overturned. Thank you, Judge.
Thank you.
I believe I have all the remaining arguments, so whichever the court would like to do.
Let's finish up topic 9 with your contention that the death penalty should be struck because it violates international law.
Thank you, Your Honor. So that motion.
I gotta ask, Michaela, I know you done gave me some references, so I'm pretty sure you're not playing in the chat. All of that happened? Because I'm just picking up. This came across my desk. All of that happened, Michaela?
Motion is largely premised on the International Convent of, I'm gonna have to pull it up because it's the ICCPR. International Covenant on Civil and Political Rights. And so essentially the argument comes down to this. We have signed and ratified a treaty that would put, we think, additional requirements on what we would do if we're going to have a death penalty in this country, and obviously we have one. One of those is a requirement that we make sure that we're not arbitrarily killing people. And the other one is that people are not being essentially tortured.
My understanding is when the time that convention was ratified with the understanding that to the extent that it is agreeing to anything, it is agreeing to afford the Eighth Amendment protections.
That's correct, Judge. And I think to some extent, what we're arguing is the Eighth Amendment and the ICCPR work together, and that we can look at these international obligations and the Eighth Amendment and say that for them, they essentially are the same thing. That's why we talk about.
Well, I think you're looking at it from two different prisms. I think what the state is saying, to the extent that this covenant applies, which is a question about whether it's self-executing and all the rest, it only governs to the extent that the Eighth Amendment, apart from that, would have protected that situation. Whereas what I think you're arguing is that the Eighth Amendment must be read to be broader as to what international law would dictate.
I think if what we're saying is that the state would argue that we read the Eighth Amendment and that's what the international law must be, we're saying you have to read the international law to decide what the Eighth Amendment.
So you're having the international law dictate what the United States Constitution means.
Correct. And we are doing that on the basis of what the United States has said itself about the fact that they believe that they live up to these things, and the fact that we discussed the charming Betsy canon, which is obviously a very old canon and typically is just about whether or not our statutes are in line with our treaties. But I think particularly in this case, where the United States has essentially said, we signed on to this treaty because we live up by these same standards that everyone else does. We can look at what the international community thinks about those standards that we said we also abide by when we're determining whether or not we're living up to the standards in the Constitution. And
But what they said specifically is that we think that we are living up to those, even though we have and will enforce a death penalty.
And I think, which is why we're not saying necessarily that the death penalty would be struck if it was done properly. Our argument is that the way that Idaho has its scheme set up, there are far too many statutory aggravators, and some of them are just big enough to drive a Mack truck through. And so just about every murder could be charged with, and have the death penalty attached to it. And so that doesn't require the narrowing that we've said we're going to provide, and it certainly doesn't live up to what the international community would expect from us.
Yeah, I understand the argument.
Well,
and let's be honest, the international community, we watching. Everyone's watching this case. This is about to be one of them. Let's be honest. It's about to be one of them.
Falling, I'll be frank, it's falling about as flat as you would expect it to fall before our Supreme Court or the Supreme Court of the United States.
well, Your Honor, it's an argument and it must be made. So
You need to make a record.
thank you, Judge.
Your Honor, unless the court has any questions, I'm okay.
I don't. Thank you.
Thank you.
All right, let's talk about the contemporary standards of decency.
Thank you, Your Honor. So I think the main case for this one was Roper v. Simmons. Unless I'm confusing it with Atkins, but essentially the court has said that when deciding what contemporary standards are in terms of what's cruel and unusual, that the court first looks at what the state legislatures are doing and then makes a decision based on its own determination of what it is it's going to be. But when we look at those cases, they also look at other things. They look at international law. They look at what religious organizations are saying. I mean, they're obviously looking for what's the consensus going on.
I think Idaho Supreme Court said is what we look at is legislative and governmental determinations and actions.
I think that's Abdullah where they had said that. And I think that was partly because the way that it was and in those cases, it seemed like the record that was brought up to them was somewhat sparse. And so hopefully we've provided more information than they had at those times. But in those cases, the number of states that still allowed the death penalty, I think, was around 35. And as the court, as we noted, that number has dropped somewhat precipitously since that time.
And those would be the legislative activities. I think what I was, I guess, taking issue with is the idea that they would look to what religious and other sort of non-governmental advocacy groups would argue or accept.
Well, I can only say that Roper definitely looked at international law. And if it wasn't Roper, then it was Atkins. But the one about children and whether or not they can face the death penalty, they definitely looked to international law. And so I don't think there's anything that says that the court can't look at whether or not organizations have moved against the death penalty. We are becoming somewhat alone in the world in terms of continuing to make use of the practice. The number of states that are still doing it is shrinking. And so when you look at that total fabric, it's our contention that we've reached the point where the death penalty really ought to be abolished. And so that is our contention in this case. Thank you, Judge.
The judge,
Thank you, Your Honor. While Roper may have looked at some international law, I think the Idaho Supreme Court has really narrowed that window. First in Abdullah, they said, therefore, absent some legislative or executive action, a determination by this court that Idaho's death penalty statute is unconstitutional based on evolving standards of decency and public opinion is unsupported. So they're really looking at that. And fast forward 5 years in the Hurston decision, 2020, the Supreme Court reaffirmed that view and then also said, quote, we continue to subscribe to the view of legislative bodies as the basis for determining a national consensus. And so, and the reason for that, they explain in Abdullah, is that courts just aren't good at taking a temperature of public opinion and what represents society's views. Now, looking at the states that have capital punishment, according to the resources both sides have cited, there's 27 states that still have it on the books. That's a majority. They've pointed out that there's
27 states still are with death penalties. It's one of those things. You got the Menendez brothers. They looking like they are about to come home. And then you got this brother right here, charged with 4 counts. The DA office got an account. The detectives been working hard. They trying to bring justice to 4 families. Not 1, not 2, not 3, but 4 families. And the victims of this violation, because to be in your home resting and your home be broken into and you just be murdered in your home, and I'm getting different. I gotta take a closer look, let's be honest. But you have his defense saying, Your Honor, death shouldn't be on the table. That's what this whole hearing is about. The hearing is about, in today's time, is death should still be on the table. Execution. Back in the day, they used to do it by hanging. Now they use lethal injection, and I think they used to use electricity. But in Idaho, they have a firing squad or lethal injection. Did y'all know that? Let's go.
There's gubernatorial moratoriums in 6 of those, which is true. But that means worst case scenario, there's 21 states that still have the death penalty on the books and can use it. And what the Idaho Supreme Court said in Hurston is that we're looking for a national consensus. And we're nowhere near a national consensus that the death penalty is somehow immoral or improper or indecent. I would also just note, it's not enough if what you're trying to show is a national consensus, it is not enough to just point to the fact that a state doesn't have the death penalty. You would have to show that the state removed the death penalty because that state believed that it was immoral and improper. So for example, if a fiscally conservative legislature just decides they don't want to fund the death penalty, but they have no moral objection to it, that's not evidence that there's some societal standard that would.
What do you take of evidence from a state who is not enforcing the penalty because, for example, an executive of that state is morally opposed to it and has the power to preclude it from being applied? Should that be considered?
So the Idaho Supreme Court did mention executive action, although in Hurston, they seem to say the better picture is painted by legislative bodies. And I think part of the reason for that is because the executive, it can just depend on the administration that's in power at that moment. A perfect example of that is the United States. The death penalty is on the books. It's currently not being applied, but shortly before the current administration, it was. And I think it's safe to assume that it will be again here shortly. The other thing you have to look at is, why is the executive doing this? For example, the defense cites that Tennessee has currently a moratorium. True, but the governor did that because he said we need to take time to fix the execution protocol. That's not evidence of a national standard that the death penalty is wrong.
So in a state like Tennessee, are they still in the sentencing capital sentences, but just not carrying them out, or have they stopped even trying capital cases?
I can't answer that definitively for Tennessee. My understanding is that they still try them and impose the death sentence, but that it's just not being carried out. I know that to be true, for example, in California, juries are still imposing the death penalty. I know in Ohio, another state that they've pointed to where there's a gubernatorial moratorium, there are 30 scheduled executions in that state. They keep getting pushed back, but the reason they're getting pushed back and the reason for the moratorium is they can't find chemicals to do lethal injection. Again, that's not evidence that there's some standard of decency that's keeping them from doing this. They just can't find the chemicals to do it. So I think,
Well, I mean, you could imply that the standards of decency as applied by the pharmaceutical companies who refuse to take part in it is some measure of that.
potentially, yes. But I think, again, going back to the Idaho Supreme Court's decisions, we're looking specifically at executive and legislative action. And the fact that the legislature or governor is saying we would do this, but we can't get the chemicals, is actually evidence that they still support the death penalty. So I think no matter how you read the numbers, we're not at a place where there is a national consensus that the death penalty is indecent. And so we think the court should continue to follow what the Idaho Supreme Court said, also Abdullah and Hairston, and reject their motion. Thank you, Your Honor.
Buttle?
Just briefly, Judge, I would caution the court trying to figure out why it is that a particular state either dropped the death penalty or imposed a gubernatorial moratorium. I mean, I think that these things are complicated. That looks an awful lot like trying to figure out from legislative history why something occurred. Half the time, what you see in the questions doesn't necessarily tell you what the legislature had in mind when they finally voted. And so I think the first step, as the United States Supreme Court has set it out, is just to look at the numbers. And then after that, the courts can consider other things.
Or 2021, if you take into account moratoriums. How, I mean, certainly more than a third of the states, how does that represent a consensus?
I would argue that the consensus can also come from the trajectory. So the fact that so many states dropped the death penalty within the last 10 years, and that appears to be the direction that things are going, is something that the court can take into account. I also note a lot of these states that have death rows and don't have a moratorium still aren't actually executing anyone. And so the actual number of executions in the states that are actually executing anybody is even than that. I think it's something like 13 jurisdictions that are actually doing executions. So anyway, for those reasons, Your Honor, we are asking that you strike the death penalty.
Thank you. All right. I think that leaves us with your motion to trifurcate the proceedings and to apply the rules of evidence in the penalty phase.
Right. So, Your Honor, I tried a case via the trifurcated method. It went smoothly, and we moved this court to do the same thing. If it's not trifurcated,
which case was that?
That was Renfro.
Which one?
Renfro. If it's not trifurcated, what happens at the in the penalty phase is the state would be putting on both statutory aggravators and non-statutory aggravators. I think the states argued that some of those things.
Isn't there a post-conviction proceeding in which it's alleged that that is ineffective assistance to allow the trifurcation because you make the jury decide about whether or not an aggravating factor is there in the absence of any mitigating evidence that might otherwise affect their decision?
I'm sure there is. But I can't say that I agree, because from a jury's perspective, I mean, you have to realize that these are people who have been pulled in, they don't have legal training, and now you're asking them to make a bunch of different decisions at the same time. And as we pointed out, I mean, we can go back and forth about, what's the, if you don't trifurcate, you're going to put on the victim impact during the penalty phase with everything else, right? And so whether or not there's even a statutory aggravator is now going to be influenced by all of the things that are emotionally really powerful. And so, I mean, we can go back and forth about, who does that prejudice. At the end of the day, a trifurcated proceeding is just simpler for a jury to do their job. They have to be able to make a decision about statutory aggravators to even have a death penalty in a particular case. Being able to do that with just a standalone, do these things actually exist first before you start to get into the mitigating and aggravating? I mean, you can put on some mitigating depending on what the aggravator is at the aggravating portion of the case. You can talk about future dangerousness and things like that, assuming the court decides to let it in. But if you don't do it this way, what you risk is that a jury is going to be influenced by non-statutory aggravators, victim impact statements, and on those grounds, say yes to one of the statutory aggravators. And you also are telling the jury, these things you have to find beyond reasonable doubt, but these things you don't, and do all of that at the same time. And I mean, the studies have shown that juries really want to get these things right, and they really want to follow the law, but oftentimes the instructions that they get aren't really that clear. And I think adding to their burden by cramming it all into one hearing, it's unnecessary. The court has the ability, I think, under Rule of Evidence 106, to let them do the function that they're supposed to do with the statutory aggravators, and then that way they can make that decision. And if they don't find any, you don't even have to do the next part. But if they find one, then you open it up into the state's case in aggravation and the defense case in mitigation. In terms of using the rules of evidence, as we pointed out, a number of courts have said, confrontation clearly needs to be able to apply. You have discovery that needs to go out. Rules of evidence are helpful, and they're certainly helpful when you're talking about the statutory aggravators themselves. That's an area where if you're trying to make a accurate determination of whether or not those things exist such that you can have the death penalty, the use of the rules of evidence is, I think, can be detrimental to both sides if you just.
I mean, how many of y'all think he's cooked before? I mean, we don't know the evidence. We don't know. They're not going to show us their head in hand. They're going to save it definitely for trial. We watched one of the fathers of one of the victims say that he has great faith in the detectives that's working on this case, even though he don't get the hour by hour, minute by minute, second by second feedback he want. He still have good faith in it. Now, I have a poll going. How many of y'all think the judge, the judge is really thinking right now. He got that thinking cap on. How many of y'all think he's going to keep the death penalty on the table? I mean, keep the death penalty on the table. I got a poll going. Y'all let me know in the poll.
Kind of allow willy-nilly whatever to come in. So for the other reasons we put in the brief, Judge, we are asking the court to consider doing this as a trifurcated trial if it gets there. Thank you.
And Your Honor, to briefly address the point about the confrontation clause and the rules of evidence. The defendant has fairly acknowledged in his brief that the Idaho appellate courts have issued binding precedent that's contrary to their argument today. The state's not going to belabor that point. I think the case law is clear and the state briefed that. As to trifurcation, the defense has yet to lay out what exactly this process would look like. And what I mean by that is, at what point it appears, although the defense has not explicitly stated this, that they would encourage this court to adopt a procedure where the the state puts on all of its aggravating evidence for all of these statutory factors, and the jury then goes to deliberate on these factors without hearing any of the mitigating evidence. Now, this is very concerning, and particularly the state briefed this. You take the propensity aggravator, where the jury is tasked with determining whether or not the defendant's going to pose a continuing risk, to send them back to deliberate without allowing them to hear evidence in mitigation. That's very concerning to the state about what that might do to, for example, the appellate record. And I think that post-conviction proceeding in the Renfro case really highlights the concerns with this procedure that they're asking the court to adopt. As to the assertion that this is simply too confusing to the jurors, the court will instruct the jury on what the law is. And as we've argued on these other motions, the court can't just start with the assumption that jurors aren't going to follow the law, that it's simply too concerning or too confusing for the jurors. The jurors will receive instructions. They are presumed to follow those instructions as a matter of law, and the court should assume that these jurors will do as they're instructed. And unless the court has any questions for me, that's all I have. Thank you, Your Honor.
Well, for the record, it really wasn't that confusing. We had the propensity aggravator in that case. We put on evidence that pushed back against that at that point in the case. It's cleaner from the jury's perspective. It was cleaner from our perspective. I don't think we even argued about it. I think the state just went along with it. And I thought it went pretty well. And I definitely want to push back on the idea that, you know, we have a tendency to have these tautologies in the law where we say, well, the jury is great and they'll figure it all out. And so long as we tell them what to do, then they've done what they were told. And there are studies that show that's just not accurate. I mean, there's the jury project. You can read what it's like for people to go through these things. And when we're talking about whether or not somebody's going to be put to death, I think it's important that we, really think hard about how these people are going to make these decisions. If we're going to do a normal, just a penalty section, I definitely think it's something that's going to require some additional instructions. I know the Supreme Court just recently updated a lot of the ICGs, which is great, something that I've been advocating for. But there are additional things that I think are going to have to be told to a jury so that they can understand how that would function. And if you trifurcate it, it's going to make it simpler for them to understand, okay, you've now found this person guilty. Now you're going to be determining whether or not one of these statutory factors exists. This is what they are. This is how they're defined. You have to find this beyond a reasonable doubt. The state's going to do an opening statement and a closing. They'll put on evidence as to whether or not these things exist. This defense is going to come in, question those things, put on their case why those statutory aggravators don't exist. And you're going to make that determination. If you make that determination, then we get to a sentencing proceeding where the state's going to be able to put on any additional aggravators that it wants to put on, and the defense can then put on any other information that they have that's going to be in mitigation. It works, and it worked, regardless of whether or not the SAPD doesn't agree with me. I'd ask the court to consider it. Certainly, if the court decides not to do it, we'll have lots more conversations about how best to do.
It's an intriguing idea. The concern, of course, is the desire to do this case once and not twice. And there's a protocol that has been approved by the appellate bodies versus the one that you're proposing now. And so that's always in a trial judges who tend to be fairly risk averse difficulty.
Yes, sir. Well, thank you.
Thank you, sir. All right, my dance sheet indicates that we have covered all the topics. Did I miss anything from either of your perspectives?
Not from the state, Your Honor. No motions, Your Honor, but I think Ms. Massa has one thing.
One housekeeping.
Sure.
Judge, we submitted Professor Cover's PowerPoint and her data. We filed it this morning under seal. We had a conversation that you thought that that should probably not be under seal. Definitely with the PowerPoint, we have no issues there. It was filed with one thumb drive. We discussed letting us look to see if there is victim information that needs to be redacted. So what I'd like your permission to do is file an amended Exhibit A, and if we'll get things redacted. The one that's filed and you are inclined not to seal, I just don't want it to get out there before we've had an opportunity to review that and redact names.
I'm assuming the state doesn't have an objection to that.
No objection, Your Honor. Thank you.
All right, and that's fine, counsel. Let me address, that brings up a good point in terms of just process for filing matters that need to be sealed in some way or the other. Because as we know, the rules for filing require them to be physically filed if you're seeking to have them filed under seal, which causes some difficulty for most of you who are not in the Treasure Valley area. I think perhaps the best way to deal with this is if you're going to file something and there's some portion that needs to be under seal, if you would provide a redacted and an unredacted copy. So for example, I think the defense filed a recent request for discovery and had an exhibit attached that they felt should be sealed. I'm assuming that's why they requested it to be sealed, was because of the exhibit. So you would file that one with, the exhibit being a blank page saying redacted, and then provide the court and opposing counsel a courtesy copy of the unredacted, and then you can file the unredacted when you are here to get it filed under seal. And then we can, the public, have the redacted version so that we, as much information as we can make public, we can.
We'll do it that way. Thank you.
That works for everybody.
Thank you, Your Honor.
Else for today?
Nothing else for today. There was a motion filed that got placed under seal that the court was going to schedule.
Is that about your jury voir dire procedure? Yeah, I think that's probably more appropriate to take up as we get closer to the pretrial than anything, because it really deals with essentially what is and isn't allowed in voir dire and in questioning. So I think we're just a little early in the game yet to get to that, from my perspective at least.
Your Honor, the only thought I have about that is perhaps talking about that may cause the court to think we should begin voir dire maybe a tiny bit earlier than is currently scheduled.
Well, we can, I think our pretrial is in May, correct?
I don't recall.
I think it's in May.
On
And our voir dire is set to begin in August or late July. I can't remember. So I think we have some flexibility there, and perhaps we'll address it at another hearing before the pretrial. I just thought with the number of motions we had today that it was probably something we could save for a later day.
Fair enough. Thank you.
All right. Anything else?
No, thank you, Your Honor.
So that I'm clear on the record with respect to why
All right, boom. We about to end this video out. Appreciate everybody that tapped in. Hit that subscribe on this plan, y'all. We about to get to what he says, man. Hopefully we get the answers to the questions. Will he keep the death penalty on the table? If you didn't already, participate in the poll before I end it out, because it look like we about to end this one out. I did the other poll. Y'all said definitely do the content. Like the judges said something different from August, but we gonna get a closer look. We gonna keep in touch, and as soon as this thing start up, I'm gonna do my live reaction. If you're new to the channel and you didn't already, hit that subscribe. Over 500 subscribers in this live stream, y'all. I'm not making this up. You can go look it for yourselves. I really appreciate the love, the support, and everybody that hit that like button. Almost 200 likes on this video. I appreciate that. In the streets with it, man. That's these YouTube streets. Content after content. City to city, state to state, and all across the country.
It's we. In the streets with it. These YouTube streets. Let's build it. Content after content. We on the block. Lego. And as a daily reminder, hit that like and subscribe so you can get the vibes, you know it, and notified every time. Let ride. It's sweet. It's sweet TV.
I sealed that. I don't think you submitted that intending it to be sealed originally. The reason I did is because it had in there specific questions that can and can't be asked of folks who are being questioned for voir dire. And because of the extensive publicity here, I don't want to unnecessarily limit our available group of veneermen because they've read something about what questions to specifically expect to be asked. And so that was my reason for sealing that. Okay. All right. Well, thank you. Everybody have safe travels back. I will take the matters under advisement and issue written opinions forthwith. Thank you.
All rise. Court is in recess.
So I think it's safe to say that we're going to definitely cover this. This was just a tryout, and it was one of the biggest streaming lives I did in a minute. So we definitely going to be covering this. Thank you to everybody that came, gave information, participated in the chat. All of that, y'all. We going to get up out of here, but before I release you, hey, we living in a different times, y'all. You just don't know. You don't know. Only thing we can do is the best we can. That being said, y'all stay blessed out there, man. Do the best you can. Be the best person you can for the people that you love. I appreciate everybody that came to the channel, hit that button, that like button. I can also appreciate everybody that hit that subscribe button. A lot of subscribers. But most importantly, I seen a member. I wasn't at the station. We got memberships as well, and members only content, exclusive content. We got a member that I didn't get to see who it was, but I definitely appreciate whoever that was that became a member by hitting that join button. Now, other than that, I have nothing else for y'all. I hope y'all have a blessed night or day wherever you at in the world or in the United States, East Coast, West Coast, Middle Coast. All y'all, man. I see the UK in the building. Big salute, bro. Big salute. But we are out, man. Another one, y'all. Another one for the books.
Real talk, what you gonna do when the pressure on? Fans listening, it's tap you dead.